Can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces turn stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious, make Sylvia spring. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Good morning, everybody. Good morning. Good morning to you. Good morning, my wonderful people. Good morning to you. Hey, guys. How's everybody doing this morning? You guys ready? Well, this morning is the oral argument for Sean Diddy Combs. And the argument starts at 10 a.m. So we're going to be listening together. How about that? Y'all happy that you're going to be listening together with me? You're going to listen with me this morning to the oral argument? Yay! Hold on, let me show you my face, y'all. Hold on. Y'all got to see my face. My beautiful face. My awesome, beautiful face. Morning. Good morning. Good morning to you. Good morning, my good people. Good morning to you. You. All right. Hey, Lise. What's up, Lise? Lise, I'm going to put some lip rouge on my lip. Hold on, y'all. Let's put some lip rouge. Hold on. Try to get some color on my lip. Hold on, people. Okay. There we go. Kisses to you, people. Kisses to you with some lip rouge. Y'all, I feel beautiful. Let me tell you something about life. We're going to have a conversation. Oh, okay, hold on. Let's go back. Because we got time. It starts at 10 o'clock. I got it set and ready for you guys. right? Got it set and ready, so we're not going to miss anything, okay? And our argument is being televised, not televised. It's on you know what I mean, right? You know. And I'm gonna have it on this thing for you guys to hear it. You're not gonna see it because they don't have visual. They only got sound, okay? So you guys gonna hear what they got to say instead of you're not gonna be able to see anything, okay? If you're gonna see something, you're gonna have to be down there at the courthouse in New York. And I'm not in New York. So I said, you know what? We are not going to be deprived today. We're going to listen to it together as a group, right? You're going to listen to it as a group. So I set myself together. I put my little alarm on and I said, let me go ahead on and let these folks do it. Okay. All right. You know, we got to do it. You know, we got to do it. Do it well. All right, here's what we're going to be listening to. Here's what the argument is going to be about, okay? Well, today Sean Diddy Combs is currently challenging his prostitution-related conviction, which was a 50-month federal prison sentence, right? And he's going to be before three judges. Three judges is going to be on the panel of the U.S. Supreme U.S. Appeal Court of the Second Circuit. It's at the Second Circuit, right? Okay. Here's the grounds for appeal. Okay. There are two primary legal challenges that his attorney is going to challenge. Okay. One is going to be about the First Amendment claims, right? And the second one is going to be the grounds of the conviction, the Mann Act. Okay, let's talk. Okay, Mr. Combs' legal team argues that the sexual encounter was the center of the case, right? Which was called the freak-offs, right? They were highly choreographed performance intended for private use, right? Amateur pornography, and should be protected by the First Amendment, right? Freedom of expression, freedom of speech, freedom, that freedom, right? And they saying that the sentencing was excessive. It was way more than most people who have been accused of that type of thing, right? Most people got like a year or some 2 years, not 50 months, right? Not 50 months. That's excessive. And the sentence they're saying is unlawful and unconstitutional because the trial judge, right, allegedly factored the conduct of Mr. Combs, which was already acquitted. You remember? There was some things that was acquitted, right? Which was the traffic and the racketeering. Those charges he was acquitted of. So they're saying that he's being punished for something he already been acquitted of, okay? Now, the second grounds was the Mann Act. Okay? Transporting people from across state line for the P word, prostitution. Okay? But he was acquitted for several of the charges that it had to do with the trafficking, right? And racketeering. So, and also, he didn't only get the 50 months, which is 4 years and 2 months in prison. He has to pay $500,000 in fine, right? Imprisonment. He's currently at, Fort Dixie, which we talked about before, because I had told y'all, but no, I didn't believe me. He was there until, they had to get it from the big news because they didn't think I was credible, right? Okay. All right. So that's what they're going to be arguing for today. The the excessive sentencing and the Mann Act. So those things are what they're going to be arguing about today. Okay, so that's what's going to happen. Because you think so, huh? Okay, we also have one of them that comes in here with a little nonsense, but today, not going to have it. We're not going to entertain it. Not me. Not today. I'm going to be at peace. All right, well, guys, it's got about a few more minutes. Let me go ahead on and get myself together here, so we can get started for this live. All right, let's go ahead and all right. Okay. Hold on, let me send this to myself. Self, get this. Let me send this to me. So you guys can get ready. All right, let me send this to myself so I can have it on the computer. Copy link and put it on my so we can get ready, get started. Yeah, I got the hiccups. I got the hiccups for some strange reason. All right, so I just sent it to my email. Hold on a second, y'all. Let me pull it up so I can have it. It's going to start in 2 more minutes on this thing here. We're going to get started. Hold on. Let me put my little overlay on here so we can do an overlay. Just 1 second. Let me do my overlay. What overlay should I put on here? I need a better overlay. Let me send this video. Let me send this thing here. Let's send this thing to my computer so I can have an overlay. Hold on, y'all. Hold on. Thank you, person. I appreciate you. Somebody had just texted me this. Thank you, person. I got to put my overlay on there first. Hold on. Let me put my overlay. All right, hold on. Here we go. I'm going to download this overlay. Let me add this onto my thing. Add this file. Let's do this. Boom. Okay, we're going to put this as my overlay. Okay, it's going to be my overlay. So when I go ahead and put this in here, okay, let's do this. It hasn't started yet. Hold on. It's going to start in a few minutes. Once it starts, we'll be ready. All right. Once it starts, it will be ready. I have to put my overlay on so you guys could be ready. We're waiting for it to start. People. How long did the ruling take, Benny? It could take a couple of months. Take and since they're doing it expedited, so you might hear it in about 2 months. In about 2 months, you'll hear the conclusion. This most of the time it takes a little while. Rah rah, rah rah is in here, y'all. Rah rah is here. Rah rah. I thought you would be going down to the so CT Benning is probably going to the judges decide today. No, Juicy Love, no. It's going to take a few months for them to decide. Since they expediting it, it's probably going to take about, no, I'd say no longer than 2 months to get an answer. No, they're not going to decide today. You know, I'm going down to check in on Sean G at lunch. Okay, it's going to be over before lunch, rah rah. Is he going to be? Oh, he might be outside still talking. Yeah, you know how Sean G is. This is going to last about 20 minutes, I would say. It's 10 minutes for the defense and 10 minutes for the government, and it's basically it. About 20 minutes, the most 30 minutes. It's going to be a quickie. So we're waiting for them to start. Will it be live streaming? The only streaming you're gonna be listening to it. You will listen to it. I'm live streaming the sound. There's no video at all. They don't have video there. Then I mean, unless you're in the courtroom, you'll be able to see them. But right now, you don't see them. You're only gonna hear the voice. It's not gonna be 45 minutes, Mr. Smiles. It's always super short. Super short. I've watched these several times in the Second Circuit. Second Circuit is real short. They don't play. It's not gonna be that long. I promise you. The longest I've ever seen is 30 minutes. That's the longest I've ever seen. I've watched several of these. I've listened to them anyway. And I believe Shapiro is the one that's going to do the argument. So we should be getting started in a few minutes. Let's see. The judge's questioned Alex Murdoch appeal long. But remember, that's state. Alex Murdoch is a state. State is always longer. State is always longer than federal. State is always. Yeah, and federal is real, like to the point. They don't ask too many questions. I've watched quite a few of them. They don't ask that many questions. They don't ask that many questions at all. The most I've ever heard them ask like 3 or 4 questions. Do we have an update on Faust? Ashley, as far as Faust, he has called me a couple of times, but I've been missing his calls. So I probably will call him. I don't have funds on the on that account anymore. I had like $5 left over it. I don't have any funds, so that's one reason I don't do any more calling. So but I'm hoping. I didn't get a chance to talk to Mr. Steele on whether or not he was taking the that case. I probably email him, I text him right before it and see if he is on it. You know, I'll do that for you guys. I'll do that. I'll ask Mr. Steele. I mean, most of the time I don't try to get it into what his cases are unless I'm gonna go to um visit it. And what I'll do is right before, because the hearing is on the 12th of June, right before the 12th of June, I'll text him and find out if he's on it. You know what I mean? I try not to all right, we got 9 more minutes. It should be starting in 9 more minutes. 9 more minutes. 9 more minutes. Again, you guys heard what the two arguments are going to be. Yeah, I got to talk to you guys about this little case of that just I heard about. And that who's arguing? Shapiro's arguing. I don't know who's arguing on the state, on this federal, the government side. I don't know. Good morning, sunshine. Don Neezy TV. Good morning. Good morning. We are here. Got 150, 15 of you guys in here. You guys want to hit the like button for me, please? You guys are going to hit the like button for me, please. Come on, hit the like button for me. We're waiting for it to begin. It has not begun. It begins in another 7 minutes, guys. 7 minutes countdown. 7 minutes countdown. We are set, ready to listen to it. Hopefully. Oh, you know what, C.T. Bennett? You are wrong for that. You are absolutely wrong for that. You are going to be, I'm going to have to get a switch from the backyard on you on that one. CT Benny, oh my goodness, you're wrong for that. You're wrong for that. Let me go get a belt. Let me get a belt for you. You are wrong. Absolutely wrong. Out of order. We got about 6 more minutes, guys. 6 more minutes for it to start. I hope we got good sound in there. I hope they sound work. Sean G is there. I think most of the news people there, because I was talking to them on the in our little chat group. Most of them are there. He won't go free today. He won't. It won't happen. It takes some time for them to review everything and then do a give their what do you call it? What is it when they do their brief? And no, not their brief. What is that thing where they call? What is it called when they give their answer to it? It's a term they use. What's that term? Come on, y'all, help me out. My brain just like went. What is the term they use when they have? Oh gosh, what is that term they use when they give their decision? But he could get bail. No. Rebuttal. No, not rebuttal. No, this is when the appeals court give their, not their motion. No. What is that thing called? They're not their findings. There's another word. Conclusion. Yeah, it's part of conclusion. There's another one. Conclusion and there's a word. Let me go look at what they go get. Appeal court's finding. Appeal. Their ruling. Oh, it's an opinion. Opinions. It's when they give their opinion. Appeal court decision is usually when the final. Okay, they give their opinion. Yeah. But there's something else to call to it. We got 3 more minutes, guys. 3 more minutes. Ruling, opinion. Yeah, I think that's what it is. Because it's on the. Their findings and facts. Findings of facts. Yes. Decision. Yes. Opinion. Yes. Simple Life gave it to me. Verdict. Yeah, y'all got it. Y'all got it. Opinion. You got it. Got 140 people in here waiting. We are waiting. Can you please hit the like button, guys? Hit the like button. Hit the like button, please. All right, we got 2 more minutes. 2 more minutes before they start. And I'm going to shut my mouth because you guys want to hear what they got to say, right? Y'all want to hear what Shapiro has to say. Will Diddy be in courtroom this morning? No, Diddy will not be in the courtroom. This argument is only done by the attorneys. He should be granted appeal bond pending appeal. You think they're going to do that? Nope, they're not going to do that, Mr. Smile. They should, but they're not going to do it. Hey, Milton. Hey, CMT, they got you. Look, I'm surprised you're even able to type up in here, CMT. Don't let the folks see you up in here. I'm talking about, you got some people that be looking for you. The stalkers. The stalkers be looking for you. They be looking for you, CMT. They want you to be hired. Yes, guys, please hit the like button so it can go out into the algorithm. I appreciate you guys. I appreciate everything that you guys do for me. Grand rising to you, long way from New York. So natural. Good morning. All right, Mr. Duncan. See you later. A lot of the worst cases got appeal bond pending appeal. Yeah, that's true. But you remember, he's a celebrity. Okay, yeah, it's about to start. Did y'all hear that? Can y'all hear that? Did y'all hear a boom? Do y'all hear the boom? Do y'all hear the boom? Let me know if y'all hear it. Let me hear. You didn't hear the boom? Tall glass. Here. Thank you guys. Thank you. Because she act like she can't hear nothing. Thank you guys. Let me shut up. Let me shut up before they. Okay, they're about to start, y'all. I gotta shut up. Okay. We can't talk, okay? I'll talk to you guys after this, okay? No, I'm not there. What's wrong with them? Why didn't he start? What's wrong with them? Oh, gotta be quiet. Make sure you hit the like button. It's just a sound, y'all. We don't get to see the people. Just a sound. They still trying to work with the mic, I guess. Hey, come on now. Somebody coughing. I wonder which judge is late. The mic works. Stop tapping the mic. Who do you think is late? Thank you, Sunshine. Thank you. I will thank y'all later for those who have donated. Thank you. Four minutes behind. They're late. Can we get people to come on time? Well, it looks like gonna be a little behind, y'all. Hey, Deanne. Hola. Aloha. Bonjour. Comment allez-vous? Nishiwa. Five minutes late. 10 minutes later. Thank you, 145 people that's in this chat. Appreciate you guys. You said Diddy has to put on some baby oil. Not the baby oil. See, look, Don Easy, you're making me get in trouble because I gotta be quiet.
Judges of the United States Court of Appeals for the Second Circuit, oyez, oyez, oyez. All persons having business before this, a stated term of the United States Court of Appeals for the Second Circuit, draw near, give your attention, and ye shall be heard. God save the United States of America and this honorable court.
Please be seated. Good morning, everyone. We have two cases on today's calendar. One of them, 25-267, Neil Evan Price versus Hale Global and Patch, is on submission, and the court will reserve decision on that case. I would also like to acknowledge the presence today. We have a visiting group of students from New York Law School. So we welcome you to attend these arguments that are open to the public, as all of us are. We will now immediately turn to the first case on the calendar, docket number 25-2623 CR, United States of America versus Combs. I understand all counsel are present and prepared for argument. I understand that Ms. Shapiro is appearing for the appellant, and you would like to reserve 2 minutes for rebuttal. Is that right?
Yes, Your Honor.
Good. And before we begin, I also do want to assure everyone that, as in every case, we have read the briefs and the supporting materials thoroughly. We are very well acquainted with the facts of the case, and there is no need to go into any unnecessary detail. Obviously, anything that you need to raise for purposes of argument, you, of course, will go into, but anything unnecessary, we don't need. With that, Ms. Shapiro.
Thank you, Your Honor. May it please the court, my name is Alexandra Shapiro. I represent appellant Sean Combs on this appeal, and I also represented him at trial. This case presents an important issue about respect for jury verdicts and public confidence in our criminal justice system. Multiple justices have questioned the constitutionality of acquitted conduct sentencing. McClinton made clear—
Well, actually, I'm going to jump in right there, and I appreciate that you're leading with all that. If you were going to the question of the Sixth Amendment issue, is that where you were going?
Not quite.
Okay, I will. Why don't we lead one of your arguments is that it would violate the Sixth Amendment to consider acquitted conduct. Let's put it that way. And I guess I would ask you, is that not a question that is foreclosed, putting aside whether, in your view, Watts does foreclose this on a part of the Supreme Court? It has certainly been a holding of this court that sentencing courts may consider acquitted conduct at sentencing. Isn't that right? Panels of this court have held that.
Yes, Your Honor.
So then my question is, other than preserving your argument for consideration by this court en banc or by the Supreme Court, how is it that this panel could, in your view, overrule precedents of other panels of this court?
So let me say first, and I'll get this, where I was going was towards the guideline.
Sure, but let's
And I
just start
think-
with the Sixth Amendment
I think
first.
the court doesn't necessarily need to resolve the
No,
constitutional
I understand.
question.
Assume though, because you did brief the Sixth Amendment
Correct,
issue,
Your Honor.
what it is that you would expect this panel could do in light of prior precedents of this court saying that it is constitutional for a sentencing judge to consider acquitted conduct.
Two things, Your Honor. First, as we've argued in the briefs, we believe the Apprendi line of cases, including the more recent ones, and I would highlight in particular, this wasn't discussed expressly in our briefs, but was alluded to in the amicus briefs, the Erlinger case from 2024. From the
You're
Supreme
saying that
Court.
those cases implicitly have overruled our circuit's precedents?
No, I'm simply saying that those cases further point in the direction of holding that it would be unconstitutional.
And I guess I understand that, but we typically cannot, as a panel, overrule a prior precedent of this court, full stop, unless there has been an intervening decision of the Supreme Court or of this en banc court categorically doing so. We can't find that our precedents have been undermined by subsequent developments and abandoned them. That's why we have the en banc process.
I understand, Your Honor, and if this court is not inclined to take up that issue for those reasons.
Well, it's not a question of inclination. I'm asking you why we would not be bound by prior precedent, regardless of the validity of your arguments, which maybe are good ones to take to an en banc court or to the Supreme Court. I'm just talking about stare decisis here.
Well, I don't think the court has expressly addressed this issue since the guideline amendment. I understand that the guideline amendment is a separate issue, but the reason the commission amended the guideline was in light of these constitutional concerns expressed by, among others, Supreme Court justices. But I also think there's another.
Well, I guess
piece-
I'm lost there. You're saying that there have been, I mean, if we have a binding decision of the Supreme Court in Watts, we have binding decisions of panels of this court. You're saying that we can look at dissents of the Supreme Court, which are not binding, or we can look at statements concurring or dissenting in the denial of cert as overruling binding precedent? You're not suggesting that,
Your
right?
Honor, again, I don't.
No, I just want to, are you suggesting that?
We're preserving the argument.
That I get.
Okay. I really don't want to spend a lot of time on that, if I may.
Well, we're going to be here for a while, so don't worry about time.
Okay.
Oh,
good. Thank you very much.
Give him more time.
So
Okay.
there is a second piece of it, though, that is relevant to that question, which is that I believe that precedents of this court in the 3553 analysis, including Vaughn and Johnson, have held that notwithstanding the rule that Your Honor referred to, that district courts must specifically explain in their arriving at their sentence, they must specifically consider the acquitted conduct and, the jury's acquittal when assessing the weight and quality of the evidence that the district court is relying on. And that did not happen here. So I think that's important too. Now, if I may, I'd like to go to.
That line of argument I'm familiar with. And I'm going to apologize. I'm not familiar. Where did you raise that issue with the district court below, that even if it is constitutional to consider acquitted conduct, he should consider the weight and quality of the evidence below?
Well, first of all,
That's the Cordoba Gigante line of cases.
it's, we cited the Vaughn case in our papers. And I
Before the
believe-
district court.
Before the district court, and I believe it was in our reply brief. But I would also just point out that throughout our papers below, we made abundantly clear in over 100 pages of briefing that for multiple reasons, the district court shouldn't consider acquitted conduct. But we
No,
did-
that's a distinct, there are various arguments one can make against acquitted conduct. One could make a Sixth Amendment argument. One could make a guidelines argument. One could also make the gigante line of argument saying it is permissible, and yet you are not, as a district judge, compelled to take into account acquitted conduct because you must also consider the nature and quality. And arguably, I suppose, under some lines of cases, one would ask the district court to adopt a higher standard of proof when
That's
doing
not
so.
what I'm really saying. I'm talking about what Vaughn says about what Vaughn says specifically. I'm not suggesting that.
Vaughn just says that the court should consider the acquittal when assessing the weight and quality of the evidence.
Correct.
That's it. It's one sentence in Vaughn. And then it goes, as Judge Nardini referred to, into citing Cordoba and Gigante. But how did Judge Subramanian not do that here?
Didn't do it at all. If you read his statement of reasons, he simply says, I'm only sentencing you for the conduct you were convicted of. And then he goes on to discuss all of the acquitted conduct.
But at the sentencing hearing, he acknowledges that the acquittals. And he says, he acknowledges you were acquitted of these charges. Are you arguing that under Vaughn, there needs to be a detailed explication as to each fact, how the acquittal on the other charges goes to the quote weight and quality of that evidence as to each piece of conduct considered? Or is it enough for the district judge to acknowledge, I get it, you were acquitted on these charges?
No, it's not enough. Obviously the judge acknowledged that he had been acquitted, but that's not enough. That's just make weight. And I think in both Vaughn and in Johnson.
Make weight?
In other words, he said, yeah, there was an acquittal, but he didn't explain.
You mean he didn't mean it or he wasn't thinking it? What does make weight mean? It's a rather disparaging characterization. And I want to understand what you mean by it.
Well, what I mean, that's not what I mean, just to be clear. My point is simply that what Vaughn requires and Johnson requires is not just an acknowledgement that there has been acquittal, but some sort of discussion of why the judge, notwithstanding the acquittal, finds that the weight and quality of the evidence supports enhancing the sentence. If I may, I'd like to go on. McClinton made clear the Supreme Court would take up the issue of the constitutionality of acquitted conduct sentencing if the commission didn't act, and the commission did act and amended the guideline to ensure that not guilty really means not guilty. And this case is exactly what the guideline was written to address. Mr. Combs was acquitted on sex trafficking and conspiracy, but convicted on prostitution charges that didn't require proof of coercion or conspirators.
Well, we're going to get to coercion and all that. But let me pause on a couple of these guideline questions and ask you why we would even need at least some of them to get into this debate about the scope of acquitted conduct. Let's start with the leadership enhancement. My understanding is that under the leadership enhancement, as the guidelines provide, it can be imposed if there are at least 5 criminally responsible participants. Is that correct?
Correct,
So you have Mr. Combs, who was convicted, correct?
correct.
So he's one. You have the 2 escorts who traveled across state lines. I understand that you are trying to challenge the convictions on the theory that they were not actually planning to engage in this specified forbidden activity, but assume that they were, and that we were to upheld those convictions. Those 2 would be criminally responsible participants, correct?
Well, the district judge relied on Christina Coram and Mr. Combs's employees and certain employees.
Yeah, but if there were 5, we have enough. Didn't he also rely on the 2 escorts?
I don't think so. Your
Okay,
Honor.
well, let me ask
And
this.
I
Let me
do
ask this.
wanna
Here's my
highlight-
question. Here's my question. Would the 2 escorts be criminally responsible participants if they traveled across state lines with intention to engage in the forbidden activity?
Well, this court has to review the findings below.
So
and-
let's stick with my question. You can go back to it. Would the 2 escorts be criminally responsible participants under the guidelines if they cross interstate lines with intent to commit the specified activity,
I
that what
actually-
is forbidden by the Mann Act.
Don't think that's clear at all under the Supreme Court precedents about the Mann Act. The people transported are often not viewed as co-conspirators. There's an old case, I'm forgetting the name of
No,
it.
the question isn't co-conspirators, whether they're criminally responsible.
Well, it's this, I mean, for the.
Not
for
the same.
The Supreme Court cases, and I apologize that I can't remember the name of it, would only consider someone to be criminally responsible if they were involved in arranging the transport or something like that, but not necessarily the person
Right,
who
I recall
traveled.
those cases.
So
Okay,
and I
so that
think-
would be your argument as to whether two escorts are out, or an argument whether two escorts are out. And what about the two named victims in this case, who pretty sure the district court cited evidence that they had participated in the arrangement of
Well, the
transportation?
government never took the position that they were co-conspirators. The
I'm not
government,
talking about co-conspirators. I'm talking about whether they're criminally responsible under the guidelines.
well, it's the same, for all practical purposes, the same thing.
Really?
Yes. Yes, I think it is, clearly.
If I cause someone to commit a crime, the person who commits the crime is guilty as a principal, and the person who caused the person to commit the crime is guilty as a principal. But that is a conceptually different concept from conspiracy, correct?
Yes.
Section 2 conspiracy, Section 2, 18 U.S.C. Section 2 is not the same as Section 371.
Right.
Okay.
If I may, Your Honor, the district court didn't rely on those others. This court has to review the district court's specific findings. The conspiracy that Mr. Combs was acquitted of clearly required the jury to find it that he acted with other people. The government argued that he led the conspiracy to the jury, and the jury was also told that if they found any two racketeering acts, even of the same type, and that he participated with someone else, that was sufficient, and yet the jury acquitted. So
Limit. But that would be sufficient to find RICO? If you find that two
it
people
wasn't a
agree, hang
RICO
on,
charge, it was a RICO conspiracy charge.
but it's not, you're not guilty of RICO conspiracy if two people agree to commit a predicate,
That's
right?
not what I said.
Right. And that's not what the district court instructed the jury,
No,
right?
the instructions, the only disputed elements were whether there was an agreement with at least one other co-conspirator, whether Mr. Combs knowingly joined the
Agreement to blank. Agreement to what?
agreement to participate in the conduct of a racketeering enterprise.
Right. So one could agree to participate in a predicate act without agreeing to participate in the affairs of a racketeering enterprise,
The
right?
jury also necessarily, on the facts of this case and the way it was argued to the jury, there's no way that the jury wouldn't have concluded that there was a racketeering enterprise if they concluded that Mr. Combs committed these
Now you seem
crimes
to be
with
going into
others.
Sixth Amendment collateral estoppel areas though, right?
No, I think what the court has to
Cole.
look at is what the jury necessarily determined in determining what the acquitted
That's a
conduct is.
collateral estoppel argument under Cole. I mean, there is this thing that we say acquittals don't constitute factual findings of anything, right? They are determinations that somewhere within the elements of an offense, the jury found something not proven beyond a reasonable doubt, but they didn't make an affirmative finding that anything else.
No.
Now, we do find sometimes in Cole, for example, that for collateral estoppel purposes under double jeopardy, the jury must have concluded something or another. And that seems like where you're going here.
Well, Your Honor, the commission wrote this guideline for a reason, right? And it requires courts to figure out what the acquitted conduct is. And the simplest and clearest way to do that is to look at what elements the government was required to prove for the counts of acquittal and the counts of conviction. And so if the jury, in this case, what we have, let's take the sex trafficking counts. The only disputed issue was whether there was coercion or threats or fraud. And that was one element. The government's case focused on that issue, its arguments focused on that issue, its evidence focused on that issue. And the jury clearly rejected that argument. So we know
So counsel,
that
doesn't the coercion as to the two pieces of evidence that the government relied upon for at sentencing, right, which is the threat to one threat to Ventura, one threat to Jane. I think one was to release the tape. The other was we're going to I'm not going to pay your rent. Doesn't that establish the intent of the Mann Act? That is the intent to violate the Mann Act. That's what the district judge used this evidence for. He says that it overlaps to this extent. That is, the RICO conspiracy overlaps with the Mann Act, and insofar as we're talking about intent here. And why don't those two pieces of evidence support his factual finding, and that there's intent for purposes of the Mann Act?
No, Your Honor, for two reasons. Okay. First of all, the intent element and the coercion elements are, as the government said, totally separate. And under our view of the acquitted conduct guideline, you have to look at it by element. And this type of analysis shows why the relevance test is problematic. But I want to also...
I understand your point about the relevancy test, but isn't that just nomenclature, right? We look at substance, not at labels.
I don't think it's nomenclature, because this is a relevant conduct guideline. The whole point of the guideline is to take acquitted conduct out of relevant conduct. And a relevance test really is another way of saying, well, acquitted conduct is not relevant unless it's relevant, which makes no sense. But I do want to talk about the specific incidents and why that's not correct.
Okay.
So first of all, with respect to the Cannes incident, there's actually no evidence that there even was a Mann Act offense in connection with the Cannes trip. So the government's argument is that threats were supposedly made on an airplane flight returning from Cannes to New York. Under Broxmire, United States against Broxmire, 616 F3rd 120 at 127, a 2010 case from this court. The court held that for purposes of the Mann Act, the intent to engage in prostitution, which has to be a dominant purpose of the travel, has to coincide in time. And there's no evidence that even on the airplane, they were planning a so-called freak-off. And moreover, there was no evidence in the record that there was a freak-off other than Ms. Ventura's testimony.
Wait a minute. Wait. Pause. You just said there was no evidence other than a witness's testimony, which is another way of saying there was trial evidence.
Right.
The jury is the finder of fact.
So this, not only was this argued to the jury in the summation, but the jury sent back a note asking for, quote, Cassandra Ventura testimony regarding Ken and the events immediately following. That's at trial transcript page 8085, which is at docket 632 in the district court. And we know that the jury rejected the notion that that there was coercion in connection with that incident. With respect to the Mann Act,
but now you're mixing two things. Let's grant you the notion that they decided coercion had not been proven beyond a reasonable doubt. But I thought you were just arguing a different thing, that the defendant did not have an intent for purposes of the Mann Act transportation, during the conflict? Because then you were saying there was no evidence that a freak-off even happened. Now, we're sort of venturing down beyond whether the jury found coercion to now say, yes, because you could say the jury found, yes, these events happened, but they weren't coerced. That's fine. But now you're saying they also found that none of this even happened. And I don't see how that follows.
That's not what I said.
Well, you said there was no evidence that the freak-off happened except for Ventura's testimony, and then you were trying to argue the jury necessarily rejected Ventura's testimony. And I guess you're saying because they rejected the argument of the government that her testimony showed there was coercion, they must have rejected every single thing that Ventura said.
That's not what I said.
Well, that was the implication, so let's back up.
That's not what I meant to imply. The point is that the government relied for its the Mann Act. The whole Mann Act charges were basically an afterthought at this trial. They took up almost no time. The government relied principally on these two charts. And if you look at Government Exhibit
Right,
1402.
I understand that, and you made that point very well in your brief. So isn't your argument really that what the government is doing here is mixing and matching? You're taking evidence from the claims that were acquitted to try to support the Mann Act sentencing for purposes of the Mann Act, but none of that jury was presented to the jury for purposes of the Mann Act.
Yes, Your Honor.
Is that a summation of what we're?
That's fair. And I think our view of the sentencing guideline as we've briefed is that the way it should be interpreted, and I think this is very simple and straightforward, is that acquitted conduct can only be used when it is also convicted conduct. And if I may, I can point to some hypothetical examples.
Before we do that, let me just focus on the Mann Act for 1 second, and I hope it will inform this discussion. So the Mann Act is indicted to say that the transport was of either, as to count 3, Ventura or the escorts, and as to count 5, Jane Doe or the escorts. But at trial, the government's theory was that count 3 is violated and count 5 is violated by transportation of escorts to engage with Ventura and Doe, right? So it's not Ventura and Doe that are transported for those convictions, isn't that right? Or because that's what the government's closing argument is talking about, transporting
Mostly
the escorts.
Yes.
Well, mostly. So is it do you believe that either the transportation of Ventura or Doe or the transport of the escorts could be the basis of the jury's conviction on 3 and 5?
I think it was that if you look at the charts, the focus is on the escorts for sure.
Well, I was looking at the closing arguments,
Yeah,
the government's
I
closing
think
argument.
that's right.
So if the theory advanced at trial is that the escorts are the ones being transported, but we're referring to count 3 as the Ventura count and count 5 as the Jane Doe count because that's the person who was involved when the escort arrived, then how do we now, in light of that, how would we consider things like the con trip?
Well, then I would say then it doesn't count. But I think what I was getting at, and I don't think I was very clear, so if I may, I'd like to explain it a little better. The con trip, they were in con and then they flew back to the United States. They were flying home. So the purpose of the trip, even if a freak off did happen, wasn't to engage in prostitution. It was to come home. And under Miller and Broxmeyer and the jury instructions in this case, a dominant purpose of the trip has to be to engage in prostitution.
So can I ask you though, I hadn't understood the government's argument to be that the purpose of flying home from con was to engage in the activity. I thought it was the fact that he went, according to the one witness, on the plane, sat next to her, showed her the video, and then immediately turned around and arranged for the escort to travel to the hotel where then the activity happened, was evidence that this is that the thing that happened at the hotel is in fact what he intended to happen, as opposed to his argument that, no, I wanted people to travel so that I could have an attractive scene, but if there was actual sexual activity that followed, that was just something that happened. But by showing a video of people engaged in such activity in close proximity to the event that actually transpired with the activity, it showed that his purpose in making this whole arrangement was to have the activity occur, and that manifested his intent.
But that's not sufficient to establish a Mann Act violation. The purpose of the travel has
Well, it's not
to be
sufficient, but it certainly contributes to it because you have to have intent, right? So I could arrange for the intent of anyone to cross state lines, and then various activities could happen. But it's not a Mann Act violation unless I transport them with the intent that those events transpire, right?
Right, that's my point.
So
and
that's what I'm saying is, why does this not go to prove his intent, which is an element of a Mann Act violation? That the reason he had the escorts travel across state lines was so the activity would
I think
happen.
that gets back to the point I was making earlier, that under our view of the acquitted conduct guideline, that is just too far afield, and it's basically like a relevance test. You're
Well,
saying
how do you
it
prove his
tends to
intent
prove
then?
that.
So what evidence Are you saying that some evidence of
And
his intent does count as an offense conduct and some does not?
Well, first of all, if you actually look at her testimony, I don't think she testifies to what Your Honor just articulated. And in fact, the testimony establishes that they got to New York and then they had dinner and then he suggested a freak off after that.
Well, right. This is a question for the jury to infer about whether the temporal proximity between him showing a video to her on the plane and then immediately getting back to New York and suggesting it and having it play out is why he wanted the escort to be traveling.
But there's no basis from which to conclude that the jury even found that this particular incident constituted a Mann Act.
Was this incident cited in connection with the Mann Act charge? Did the government ever point to this and say this is a Mann Act violation?
No. The Mann Act, the government's discussion of the Mann Act in its closing argument was focused on this charge.
So let me, we have to write an opinion here and let's just step out of the weeds and we have to enunciate a principle, right? And the guidelines, the discussion of the guidelines talks about line drawing exercises that courts have to engage in to determine where there's overlap, where acquitted and convicted conduct overlap. Can you articulate a principle that for us to apply, if you were writing the opinion, what principle would you enunciate that is, readily administrable by courts to engage in this line drawing exercise? Can you give me a bright line test of some sort?
Yeah, let me try. If I may, I'll try to illustrate it with some hypotheticals. So I think the test should be, and what the commission intended the test to be, that courts cannot use acquitted conduct for guidelines purposes unless the defendant was also convicted of that conduct. And in order to determine what that means, you would look at whether the same element that has to be proven in connection with acquitted conduct has to be proven in connection with element or elements convicted conduct. So for example, let's suppose you have a case in which a defendant is charged with drug conspiracy to distribute narcotics, as well as several substantive counts of distribution. And the defendant is convicted of the conspiracy and with respect to the substantive counts is acquitted of some and convicted on others. When determining the drug amount, the court could not count the ones the defendant was, the weight from the ones the defendant was acquitted of for the substantive counts, but could count the ones the defendant was convicted of, as well as any other drug deals that were either proven at trial or are proven at sentencing if they're not charged in separate substantive counts. That's one example. Another one would be you could have a fraud case in which the defendant is charged in securities fraud as well as wire fraud, and it's the same exact scheme to defraud, the same false representations in both counts, but the defendant is acquitted of one and convicted on the other. The way to make sense of that is to say it's clear the defendant has been convicted of the scheme to defraud, and so you could count the entire loss amount, even though he was, let's say, acquitted of wire fraud, either because maybe the jury didn't find the wire in furtherance or something like that, but it's clear that they did find the scheme to defraud proven because the same conduct underlies the element in both charges.
To what extent does does your theory rely upon the what the government argues in terms of the evidence? In other words, the case that's presented to the jury in terms of the elements. Is that dependent upon that, or does that matter? Is that irrelevant?
I think it depends on the case. I think you have to look at the indictment and what's the charge and what's the government's theory of the case. So
the theory of the case as presented to the jury, right? It's not their theory of the case in the abstract, what may be in the indictment, but it's what is actually, they have a case to prove, right? So wouldn't it be the evidence and the arguments that the government makes to the jury?
It's definitely very important. And I think that's why, that's why we think that the the test that's used for collateral estoppel is.
And so was any of the
useful.
evidence and the arguments the government made here in connection with the RICO and the sex trafficking offenses, was any of that evidence presented to the jury for purposes of persuading them to convict on the Mann Act?
Yes. I'm sorry, were you asking just about the RICO or the?
No, both.
Both,
So,
yes.
so to what extent did the government's case at trial on RICO and sex trafficking overlap with the government's evidence and arguments on the Mann Act?
So, as the government said, itself said it was totally separate, but with from the sex trafficking counts, the overlap. Well, let me just back up. I'm
Should
not
a
sure.
district judge hold the government to that for sentencing purposes? I mean, should the district court say, well, you know, you put on all this evidence that the jury rejected, right? And now you want me to look at this evidence to support a conviction under this other, to support a penalty under this other offense that you were convicted on. But you didn't present any of that evidence to the jury.
I think you have to just start with what are the elements that the government had to prove.
Yes.
And so if they didn't have to prove, for the Mann Act, if they didn't have to prove coercion, they didn't have to prove a co-conspirator, then we know that there is no convicted conduct that includes coercion or co-conspirators. And that's really the starting point. And I think the evidence and the arguments just reaffirms in this case that that the evidence that the judge was relying on is totally separate and in fact was acquitted conduct because
well, he's mixing and matching is what he's doing, right? I mean, the district court here reached into the evidence that was used to support the government's RICO and sex trafficking case to for purposes of establishing the penalty under the Mann Act.
Correct. And he found coercion when the jury had not found coercion, including as to those two specific instances, because the government made those arguments and expressly told the jury, which correctly under the jury instructions, that if they found coercion, each of those instances would have been sufficient to convict on the substantive sex trafficking.
Were there limiting instructions given or requested during trial that certain evidence would only be admissible with respect to certain of the charged offenses?
No, and that wouldn't really have worked here because there was a RICO charge, and as I'm sure Your Honor knows, under RICO, basically
everything would have come in as to RICO, but the idea that it's admissible as to RICO but not admissible, say, as to the Mann Act.
But
So
that
I guess what I'm going to
that
is
would not have been legally permissible in this case because the Mann Act was also predicate acts to the RICO. I mean, that just wouldn't have been a valid instruction.
well, I guess where I'm going with this is, does that mean that all the evidence that was admitted would have been legally admissible to prove any of the particular offenses? So, going towards Judge Baker's hypothetical, is there a scenario here where the judge was pulling evidence that was not, I don't know what you would say, admitted for purposes of proving the Mann Act, and then it's impermissible, say, for the judge to look at it with respect to the Mann Act when he's at the sentencing period? And I guess what I'm asking is that in fact the case here, or was all of the evidence admitted for unlimited purposes such that there is no, as long as it would be relevant and probative to prove up another count, then it would have been permissible for the judge to consider it with respect to that count?
Well, I think the reason it's not permissible for him to consider it is because it's acquitted conduct. And the judge.
Well, right, but I guess
judge made
let's give
clear
you that.
he
Let's accept
accepted-
that. Let's accept that premise for the purposes of my question, that yes, it would underlie some of the acquitted counts. I think then the question becomes, is it overlapping, right? So would it be permissible nonetheless to consider it with respect to the convicted counts?
No.
And right, and I understand your answer is no, and I'm trying to get at why. So is it because it wouldn't have been admissible to prove the Mann Act count? In other words, does your argument depend on that at all? Or I think what I hear you arguing is if there is an element of the acquitted charges that does not match an element of the convicted charges, what is embodied in the element of the acquitted conduct, which here is coercion fraud, is now completely off the table for sentencing. Is that your argument?
So that is our principal argument.
Okay.
There's a secondary argument, and I hesitate to even raise it, but it's, we've made it, that even if you actually adopt the relevance test that the district court imposed, that these things wouldn't have been relevant. But I don't think the court should
the relevancy
go
test,
there.
I find your argument confusing on that because I think
Well, it's
the
not
district
a real
court
argument.
made, I think,
that's just a
frankly, I think
fallback.
the brief mischaracterizes, sort of caricatures the district court's use of the word relevancy. I don't think he's saying relevant in the sense of relevant conduct under the guidelines. I think he's taking relate to in context of having probative value with respect to one of the elements of the convicted offense, which is another way of saying it would have been admissible evidence to prove an element of the charged offense.
I think that's right. And our point in the briefing below on that, especially, and I think we make this point in the opening brief as well, is that test is far too broad.
But it's not
basically a
coextensive with
Rule
relevant
401.
conduct. Because I think in your brief, you say that blows up the acquitted guideline because it would basically, it's just a circular definition with relevant conduct. And I think that's not what the judge was saying. It would be a smaller subsection of things, much smaller subsection of things than anything involving relevant conduct.
I don't agree, Your Honor. And I think that it's a distinction without a difference because the concept of relevance, as the district court was using it, as Your Honor seems to be using it, is the same as Rule 401, which is incredibly broad. And as this court has, repeatedly held, it's a very low bar, and it basically sweeps in, many things. And
Well, no, take this. Defendant is convicted of one bank robbery. At sentencing, the judge considers 10 other bank robberies that were committed on completely different days using, and let's posit, completely different modus operandi. But it's relevant conduct. And so the judge considers all 11 bank robberies when calculating the guidelines. I don't think that one would then say that had there been a trial on bank robbery 1, all of the other 10 bank robberies would have come in as relevant evidence because under my hypothetical, where there was no common MO, they would not be admissible under 404B. So I don't think if you draw a Venn diagram, you're going to find perfectly coinciding circles for relevant conduct under 1B1.3 and relevance under the rules of evidence to prove up an offense.
Well, even if that's the case, on what we're dealing with here, this evidence of coercion would not have come in to prove the Mann Act. And clearly, it would have violated 404, 403. There are numerous reasons that I think it's pretty indisputable that if all Mr. Combs had been charged on and all he'd been tried on was Mann Act, that we wouldn't have,
But what about the idea that if he had, let's say he was only charged with the Mann Act and his defense was along the lines of one of the things the defense raised at trial, which is he never intended for the specified activity to happen after these folks crossed state lines, that it just, it just kind of happened. And one of the ways the government tried to disprove that or tried to prove his intent was saying, no, he used to talk about this all the time, what he wanted to happen. In fact, there was one time on a plane that within 24 hours before the event happened, he actually showed a woman videos of prior episodes where the activity had happened. And sure enough, within 24 hours, that's what he arranges to happen. Again, that's proof that this is exactly what he intended to happen. It is not mere coincidence. Why would that not be admissible?
That's not what the defense to the Mann Act was. Most of the case was focused on the coercion and the RICO, and to the extent—
I thought that was part of the defense, no?
No, it wasn't, Your Honor. That with all the only arguments that were made specifically about the Mann Act by the defense was the argument that based on the testimony of the and the evidence in the case was that the escorts were paid for their time.
Well, right. That's the same argument. They were paid for their time, and everything that happened afterwards was just not something that he was arranging. He was not transporting them for the purpose of what happened afterwards. It was just their time.
I guess I'm getting a little lost. I apologize. But I think the point here is that the principal point here is getting back to Your Honor's earlier questions and my dialogue with Judge Baker, is that you have to look at the elements. That's our position. You have to look at the elements. This idea that you have a relevance test is
Right.
not
But
consistent
your
with the
argument,
guideline.
but
I just want to highlight, I'm sorry.
Well, no,
Go
there's a
ahead.
question.
Sorry.
I'm sorry. Well, finish your point, and then I have a question.
I just wanted to highlight, and we've mentioned this in the briefs, but if you look at the history of the guideline, the Department of Justice wanted the commission to use the phrase relates to in the guideline. And the commission rejected that because they thought that was far too broad. And they went instead with the language that's in the guideline.
Okay, so the problem that I have with your test of an elements test is that sometimes the problem is we have different elements, right, for the RICO, for the sex trafficking versus the Mann Act. But there's evidence, conduct that can underlie the government's case, right, in all these sets of charges. And the mere fact that you're acquitted doesn't, by the very plain terms of the guidelines, right? It doesn't take it off the table insofar as that conduct is also convicted conduct. And so what we're trying to discern here is where is the line, right, for purposes of sentencing. And so you just can't rely upon a test of the because it cannot be that just because in all conduct that is underlying the element of acquittal is then taken off the table, right? It can't by itself.
Well, I don't agree with that because I think it's going to depend on the case, right? And there are going to be cases that are maybe closer than this one.
Right.
So you're going to have cases, for example, where there are maybe inconsistent verdicts, things like that. That's not the case here. This was very clear. I sat through this trial for 8 weeks. The government's focus from beginning to end was on the sex trafficking and the RICO. The whole where the debate was there coercion or was this sex voluntary?
Right.
That was the gist.
The Mann
of
Act
what
was an
being
afterthought.
disputed.
It was an afterthought. The Mann Act was just an afterthought in the
Correct.
government's prosecution. I mean, it was there, but it was effectively a sideshow. But that's the question, right? Can the government then look to all this, can the district court look to evidence presumably rejected by the jury and acquitting on these other things for purposes of finding the penalty in the sideshow? And why shouldn't we just hold the government to what it argued?
We should, absolutely. And I think the whole point of this guideline was to deal with the fact that many people in America, not just Supreme Court justices, not just other judges, but, have really questioned whether it is both constitutional and right and consistent with respecting jury verdicts to allow acquitted conduct to be used to drive a sentence in this way. And I want to highlight that, and we mentioned this in our brief, but I'm not sure we gave it the prominence it should. This sentence was the highest sentence ever imposed for a Mann Act defendant sentenced under the same base offense level and criminal history category.
Well, let me ask you about that. So would this offense be let's take the violence off the table, right? The allegations of violence that the jury rejected in the acquitted counts. What about would this verdict, would this sentence be substantively reasonable in your view, given that we also have factual findings of psychological abuse, emotional abuse, and applying these two women with drugs? One of them became an opioid addict as a result of it. Would that, presumably that's still on the table if we take away the violence.
I think that it would be substantively unreasonable under the correctly calculated guideline range, because it would be multiples, it would require a variance upward based on the acquitted conduct.
But that's not, but it's the guideline range is just, it's not a per se rule. It's a guideline and it's a starting point, but then you look at the facts of the case and we have two statutes that tell us you look at all these factors and we have one statute that says there's no limitation. And am I correct in understanding that we have this factual finding that we have two women who were plied with drugs to participate in this, and one of them became an opioid addict. And so doesn't that support the reasonableness of this, putting aside the violence?
Well, a couple of points. First of all, you're correct that that's what the district court found. The evidence in the trial is much more complicated than that.
But you don't challenge on appeal those factual findings. You're not challenging that factual finding. You're making legal arguments.
But this court has to review the sentence based on the guidelines calculation taken as a starting point. And this is actually where I was going. I don't even think I got to this. The Supreme Court in Martinez-Molina and this court in Seabrook and many other cases have held that a guidelines miscalculation is a significant procedural error that requires a remand and resentencing in most cases, even under plain error review. And so, for instance, this court has held that if you accept the guidelines argument, even in part, a significant upward variance would have been required, and a remand is required because the judge would have had to explain that variance. And indeed, this court has held that even where the sentence is within the range of the correct guideline range, a remand is necessary.
But sometimes, oh, go ahead.
Sorry, what do we do with the fact that the district judge here, after each guidelines finding, made the statement that he would have imposed the same sentence with or without this increase? It seems to me that if we accept the judge's representation that that guidelines decision, it was not what drove his ultimate sentence, that then moves us into the question of whether he could have used the acquitted conduct for the 3553A calculation. But how do we get over that sort of potential harmless error hump that he did make that statement after each increase was imposed?
So this court has repeatedly held that a major variant, that the district court cannot insulate itself from appellate review by saying that he would give the same sentence. The Seabrook is one example. We've cited others in our brief, and the Supreme Court in the Molina Martinez case, and this court in other cases have pointed out, for example, that this isn't like a new trial and a resentencing,
Yeah, but sometimes we have affirmed. I mean, I understand you can point to some cases where we say, you know what, we're not sure the guideline error really was harmless. We don't know. The judge said it wasn't, but we don't have a high level of confidence. The judge was very emphatic here.
Well,
and careful. So it doesn't sound very boilerplate. It doesn't sound like anything the district judge did here was boilerplate.
It's also clear that the acquitted conduct drove the sentencing.
And then we would get into the Sixth Amendment issue, right?
No. I'm talking about the guidelines calculation as the starting point. And the other thing that is really important here is that the district court's guidelines calculation exactly mirrored the PSR, and it seemed clear that the district court was really planning to follow the PSR. And indeed, when he imposed the sentence, he initially said he was following the recommendation.
Wait a minute. Are you implying that the district court wasn't thinking for himself and that he was?
No, not at all.
Then what does this argument about tracking the PSR have to do with anything?
It has to do with the fact that the guidelines range was very important in the ultimate sentence.
And you're saying that the district court must have placed the same weight on the guidelines that the PSR did?
No, that's not.
Then what is the implication? I'm trying to understand what your implication is. Because it sounds like you're going to a place where the district court was not thinking for itself or was somehow implicitly adopting parts of the PSR that it didn't or something.
No, Your Honor, that's not what I'm saying.
Then what are you saying?
My point is simply that this court has repeatedly held that significant procedural errors require remand. I mean, two of the cases.
That I understand, but no, I want to go back. What were you talking about with the PSR? Because I don't understand that point.
Okay, what I'm saying is that you don't know what the district judge would have done if he had understood the guideline range to be either 21 to 27, which it would be if you accept all of our guidelines argument, or 30 to 37 if you get rid of the grouping, just for example.
Even though he told us what he would do. I
Because-
understand the argument. I would understand. I don't think you made it quite this way, but maybe this is what you meant to say, that if we agree with you that all of his guideline enhancements were wrong, he never said, and even if all of my guideline calculations are wrong, I would do the same thing, as opposed to any individual thing. So if we found one guideline error, though, he said to us he would have done the same thing. And you're saying that we don't take that at face value?
That's correct, Your Honor, under the precedents. And
Well, some of them we do. I mean, there are some cases where we have reversed and remanded, and there are others where we said, well, the judge told us he would do the same. So it's harmless.
We don't have a case where there would be a significant upward variance like this. We don't have another case the government could possibly cite where the sentence was the highest sentence for any person in this criminal history category and base offense level, even including others who had a coercion enhancement. There's no case remotely like that that the government could point to. And indeed, some of these cases involve things like in the Bennett case, and I forget the name of the other one. In a couple of the cases, the judge says the guideline range is X, which is a little bit above the statutory maximum, and then sentences well below the statutory maximum. And this court says it has to go back because the judge thought the guideline range was higher than the maximum. So, in that case, clearly there's been a significant departure from what it could have been, and the judge gives reasons, but the court sends it back. And that's what the court should do here. That's what's required by those cases.
Okay.
I understand your argument. I mean, I fully understand your arguments about the acquitted conduct for purpose of the coercion and leadership enhancements, right? Those were four points apiece. But when it comes to the victim, the characterization by the district court of Ventura and Jane and the escorts as victims, that's not really, as you framed it, it's not really an acquitted conduct argument. You're just arguing with or disputing the district court's characterization of these people as victims. So that doesn't really fall into the acquitted conduct bucket for purposes of deciding this case.
I mean, I think there's two issues that we're raising there.
I know the law professors agree with us on that because they don't join you on that. The law professors who filed you, by the way, a very helpful brief. I'd like to thank them for that. But that very helpful brief did not, they stopped when they got past coercion and leadership.
That's fair, Your Honor. I think our principal argument on that, we are arguing that the acquittals show that the jury didn't believe the two women were victims, but our principal argument there is that the term victim should be interpreted according to its plain meaning, which is someone harmed or injured by the offense, and that the application note is inconsistent with that plain meaning. So even under Stinson, the grouping calculation was incorrect, and we're also preserving for further review a challenge to whether Stinson is good law.
Right, but so for acquitted conduct purposes and looking at harmless error and how this might have played out, if there was a mistake under the guidelines, we're only looking at we're talking about
It's almost double.
Right. Well, it takes us from, if we did 8, it would take us from, that would go from, we went from 50, would take us to 20. It's only, we're talking about 8 points, right? We're going
It
from
would
level
go
14 to
The
20.
range would be 30 to 37 under that scenario, as opposed to
All right,
70
right,
to 87,
right,
which
right,
was
right.
the starting
Okay.
point.
Can I ask you about the definition that the commission has given us of acquitted conduct? One of the things you pointed to contest the government's view is that there was a government proposal that acquitted conduct be defined using the word relating to or something like that. Related to. And the government has also pointed to a proposal that was before the Sentencing Commission that would use the word elements. And neither one of those was adopted. And instead they took this other definition that, as far as I can tell, they decided they didn't need to define further and said something along the lines of, don't worry, it won't come up that often. and it's going to be really easy. District judges are going to be able to figure this out. Why should we worry about line drawing? And as I recall, there was a letter from the Judicial Conference Committee on Criminal Law warning them that this was a very ambiguous guideline and that they very much should provide more clarity. And they didn't. They didn't take an elements test, which I think would have been very clear. And they didn't take the government's relating to. And they gave us one that says, don't worry, district judges are going to figure this out. And I don't know, maybe the district could figure it out. I'm having trouble as an appellate judge figuring it out. What are we to make of it if we decide that it is ambiguous? Does the rule of lenity kick in to guidelines issues? Are there other interpretive principles?
There are two interpretive principles. So one would be the rule of lenity, and the other would be the related, but maybe more important, constitutional avoidance principle. And even to the extent, I understand the court's the panel's position regarding, or Your Honor's position regarding the binding nature of those precedents we talked about earlier. But putting that aside, I think it's clear that at a minimum, there are serious constitutional concerns with using acquitted conduct. And so I think, if the court finds that the guideline is ambiguous, it should be interpreted, the exception should be interpreted narrowly in favor of the defendant.
And this is, I swear, my last question. I don't know about my colleagues. Are you aware of any other appellate courts that either have decided this issue or are facing it right now? Is this bubbling through the circuits in other ways where we are soon perhaps to benefit from the views of our sister circuits?
I am not aware of any other appellate decisions interpreting the guideline. There are some decisions, relating to the Watts issue, but.
Sure, but you're not aware of anything currently bubbling?
My colleague advises me that there's a case pending in the First Circuit on this.
Do you happen? Well, that's fine. Well, if it comes out, that's fine. If it comes out, we'll find it, but that's helpful.
Okay.
Unless there are any further questions, we have kept you up considerably past the 10 minutes. So, but don't go away because we're going to see you again in rebuttal.
I'm sure I'll have more to say.
I hope you have a bottle of water there. We will now hear from the government.
Good morning. It might be afternoon at this point, but may it please the court, my name is Christy Slavic, and I represent the United States on this appeal as I did in the district court proceedings below. Judge Subramanian correctly applied the new acquitted conduct guideline in this case. And moreover, in determining the appropriate sentence under Section 3553A, Judge Subramanian properly considered the aggravated manner in which the defendant carried out his Mann Act offenses, which is, of course, consistent.
You say aggravated manner. Let's talk about that. Why shouldn't we hold you to the way you prosecuted the case? You went to the jury and you said, this man did all these terrible things for purposes of the RICO conspiracy, for purposes of sex trafficking, and they acquitted him. And then on the Mann Act, it was just a sideshow, and you put him. I don't think there was any evidence or any live witness testimony. Just look at this. You said, look at these charts, and now you want us to rely on all this acquitted conduct that was presented to the jury that was presumably rejected for purposes of, or to allow a district court for purposes of the guidelines calculation. So why shouldn't we hold you to what you argue to the jury?
Your Honor, I have several responses, but
Please.
First is that much of the conduct that the district court focused on in imposing the sentence was not acquitted conduct at all. In fact, it was admitted conduct. The extreme physical violence that took place in the context of these freak-offs.
That's
and
not,
hotel-
okay, I get all that. I understand that. That's not my question to you. My question to you is, why shouldn't we hold, it's not what the government, what the district court relied upon. I'm asking why we shouldn't hold you in terms, or require a district court to hold the government to what it presented to the jury for purposes of, for deciding the scope of acquitted conduct, to look at what you actually presented to the jury for purposes of those charges, and then asking, did it overlap with the acquitted charges? And I don't think
Sure.
there's any overlap here.
Sure. So just backing up a moment to talk about how the case was presented. Counts 2 and 4 were the sex trafficking counts, and those, of course, were acquitted counts. Counts 3 and 5 were the Mann Act counts. All counts were charged as courses of conduct as opposed to specific instances. And for counts 2 and 4 that related to Cassie, that course of conduct related to the freak-offs that took place between 2009 and 2018, I believe. With respect to counts 4 and 5 that related to the hotel nights with Jane, that course of conduct was from 2021 through 2024. So the evidence of the hotel nights and the freak-offs related both to the sex trafficking and to the Mann Act charges. And that's how it was presented to the jury. It was never presented as this evidence relates to sex trafficking and this evidence relates to the Mann Act. There was never a dividing line.
But when you get to summation, there is, right? So you say, let's start with count 3. The defendant is charged in count 3 with interstate transportation for the purpose of prostitution related to freak-offs involving Cassie. That's how you describe count 3. I think that's right. And then you go on to talk about all of the evidence about escorts traveling. And it doesn't talk in your discussion of count 3, and similarly, it's a very, very mirrored for count 5 when you talk about Jane Doe. Doesn't talk about Ms. Ventura or Ms. Doe being coerced, or Ms. Ventura or Ms. Doe being transported. It says count 3 is about escorts traveling for the purposes of contact with Cassie, and count 5 is about escorts traveling for the purpose of contact with Jane. As Judge Baker is saying, where else can we divine the government's theory of those 2 counts other than summation, and why shouldn't we hold you to it?
So just to be clear, the government's theory was that the travel involved both Cassie and Jane and escorts. But I think
that what you said in your closing.
I don't have the exact words of the closing, but that was.
I do.
I think that your other question is, why shouldn't the government be held to what it argues?
Let me just stop you for a second, because the last thing you say on count 3 is, quote, all of the examples that I just went over showed the defendant caused commercial sex workers to travel across state lines for freak-offs. The defendant is guilty of count 3 based on any single one of these instances. Then you say, let's move to count 5. So that's how you started and ended count 3.
So the point was, the government in closing went over several examples. It was not a comprehensive list of all the instances of travel because.
No, but the theory was that he caused commercial sex workers to travel. That was the theory on which you asked the jury to convict Mr. Combs on count 3.
Sure.
Not that he caused Ms. Ventura to travel, or that he coerced Ms. Ventura into something. The theory was he caused commercial sex workers to travel. Other than the constitutional challenges, there's no sufficiency of the evidence challenge to that for good reason. It looks pretty much like he did. But that's the government's theory, right?
That was the government's argument at closing. I think kind of backing up the import of this line of questioning is, shouldn't we hold the government to what it argued in closing? And I don't think that that's right. I think the theory is, if the government made this argument, doesn't that mean that the jury accepted that argument and didn't consider any other possibilities? And I don't think that that's a fair inference.
But what we're trying to do here is to figure out where, draw this line. So the jury acquitted on certain things and then convicted on other things. So what does a jury have to rely upon? Don't you think they're listening very intently to the closing argument? Isn't that going to be very, very important in their consideration?
Of course, Your Honor, of course. But the jury in this case, was properly instructed on each element of the Mann Act and had to find each element of the Mann Act met beyond a reasonable doubt. And I think it's, as a logical matter, I think it's an impossible task to discern the minimum quantum of evidence that would be sufficient to sustain the government's burden. And I think that sort of inquiry also goes against this court's precedent, specifically the Martinez case that says a court only knows what the jury's verdicts were, not what the jury found.
Well, right. No, and that, I don't think anybody's questioning that. But the problem for the government is that there's a new guideline that says, figure it out, that basically says there is such a thing as acquitted conduct. And as Judge Subramanian pointed out, I think quite accurately in sort of speaking with the greatest amount of precision possible, there is no such thing as acquitted conduct. Juries don't acquit people of conduct, they acquit them of charges. They find that certain elements were not proven beyond a reasonable doubt. They don't find that someone's innocent. But now the guidelines have been amended, so there is a thing called acquitted conduct. We've got to figure it out. So the question is, how do we measure that? So we're not looking at general principles like Martinez saying, did the jury find something? The only place that you're going to find, I think, in our case law where we say an acquittal necessarily implies something is in our collateral estoppel branch of double jeopardy jurisprudence. And I think, I guess one question I would have for you is, why would that not defeat the government's argument, at least with respect to coercion in this case, if, for example, the jury had hung on the sex trafficking count, right? If the jury had hung on, well, no, no, my hypothetical is spinning out of control. I guess what I'm wondering is if there were some hypothetical additional count that the jury had hung on here that required a finding of coercion with respect to one of the two victims, why you would not be collaterally estopped under the double jeopardy clause from retrying the defendant on that count. Let's say there was a conspiracy to commit sex trafficking.
Well, let me just push back.
Why would that not be
Let me just push back on this hypothetical that a foundational issue that I have is that the defendant was not acquitted of coercion. He was acquitted of sex trafficking by force, fraud, and coercion. The jury was never asked, was there coercion?
Right, but we have,
Sorry.
well, under that theory, there is no such thing as acquitted conduct. So you're kind of fighting the very principle of the guideline. You're saying that because there were three alternate elements, I think, fraud, force, or coercion, that because there are three alternate elements, there is no acquitted conduct. But you have to accept the premise because the guidelines have been amended. There is such a thing as acquitted conduct. So why don't you tell, actually, let me frame it this way. Under your view, with respect to count two, what is the acquitted conduct?
So the commission thought very long and hard about this issue, clearly, and they declined to set any bright line rules.
Yeah, but now here we are.
Exactly.
So what's the government's view of what the acquitted conduct is underlying count two?
So I think Judge Subramanian's test, which is
No. That's. I think Judge Subramanian's test is what's overlapping conduct.
as a first step to Judge Subramanian's test, he described acquitted conduct as conduct that underlies the.
Yeah. So you tell me what
that-
conduct underlies count two.
What specific conduct? Yeah. Well, I think a good example of conduct that could be considered acquitted conduct that the judge did not consider in applying the exception was the intercontinental video. That, of course, was evidence presented at trial that showed the defendant assaulting Cassandra Ventura during the course of.
So that's acquitted conduct in your view.
I think that that's a fair characterization.
So that's a use of force, but the other conduct that illustrates use of coercion is not acquitted conduct.
The reason that that's acquitted conduct, in my view, is because that does not tend to prove the elements of the Mann Act.
Well,
No.
that's the second question.
No. There's two things here. You can have acquitted conduct and you can have offense conduct under the guidelines, and they can overlap. And that's why the guidelines say where they overlap, you can consider them. So the government sort of doesn't lose by saying something's acquitted conduct here, because then the district judge, if it's overlapping, can still consider it.
Right.
So let me ask it this way. There is evidence on the flight back from Cannes that Mr. Combs sits next to one of the victims and shows these videos of the events that have happened in the past, and the government's argument to the jury is that's coercive, right? That this was an implicit threat, right? His discussion of releasing these videos was implicitly, if you do not continue to engage in this conduct, I will release this publicly, and that will destroy your reputation, right?
That's right.
So it seems to me that that's clearly acquitted conduct. I thought the government's argument is that it is also offense conduct. And therefore, because it's overlapping, the judge was allowed to consider it. So I want to ask you about just the first part of my question.
Okay.
In your view, did what Mr. Combs did on the plane back from Cannes also constitute acquitted conduct?
So I think the answer is maybe. I think it depends on the
Maybe.
definition of acquitted conduct.
Okay,
but
under the government's definition, is it acquitted conduct?
I think the judge properly.
No, under
Not
the
the
government's
judge.
view.
You.
Forget, let's pretend it's before sentencing happened. Under the government's view, is that acquitted conduct?
I don't think that because the defendant was not acquitted of coercion, I don't think
How
it's
was he
necessarily.
not?
Because
Unless
he-
you're saying he wasn't acquitted of anything. Because if there was fraud, if there was force, there was fraud or coercion, he's guilty, right?
What I'm saying is, no, I don't think that that's right. It's not just if there was force, fraud, or coercion, he's guilty. He had to know or recklessly
Right. There are
disregard.
multiple of elements. But I think what your argument would lead to is that there's no such thing as acquitted conduct, because there's always multiple elements. One can't, from a jury's acquittal, ever know which of the elements they found unsatisfied. Ipso facto, there's never a category, there's never a bucket that's filled with something called acquitted conduct. Tell me why I'm wrong about that. In what world is there a bucket that's full of acquitted conduct in your position?
Your Honor, I think the this case is I think presents a lot of gray lines, and I think that the cases that come up in some of the dissents that the panel has already mentioned related to drug cases, for instance, where there's a conviction on a conspiracy count and an acquittal on a distribution count, or vice versa. And there's a special interrogatory where the jury finds specifically some amount of drugs. Like, I think that is very easily described as acquitted conduct.
Absent a special interrogatory, when does your test yield anything that constitutes acquitted conduct?
Your Honor, I think that in those sort of more straightforward cases where facts were presented directly to the jury and rejected by the jury, I think.
When does that ever happen except with a special interrogatory?
I think that can happen in, for instance, a 2-count drug distribution case. In one count, there's a conviction. In one count, there's an acquittal. I think the acquitted weight of the drugs would be.
Well, but each of those counts, let's assume it's a distribution count. Each of those counts has multiple elements, right? Knowing what the drug was, distributing it purposely, right? I purposely handed it to you. That's how I knowingly distributed it. But also knowing that it was heroin, right? Because the defense might have been, oh, I thought it was fake drugs. I thought I was cheating, right? Each of those has multiple elements. So you're always going to be in a position, if you're the government, taking the position I think you're taking, of saying, well, I don't know whether the jury found that he didn't know it was heroin, or I didn't know that he thought that he was purposely distributing it, or whatever it might be. So I don't understand your argument.
I think going back to the guideline itself, which does create a thing called acquitted conduct and convicted conduct, the commission deliberately did not define either term, leaving us in this position.
But it clearly must have some content.
Exactly. I think
And it
that's
can't
right.
be what we have always said under the Sixth Amendment is true, that there is no finding implicit in a verdict of acquittal. So that's off the table as to what the commission was trying to say.
That's right, Your Honor. And what the commission did say is that the court is in the best position to determine what is acquitted conduct and what is
Right,
convicted
but
conduct.
according to some rule of decision, not in terms of arbitrarily deciding A in one case and B in another. So we are tasked, as the district court was, with coming up with an articulable rule.
Sure.
So here we are.
And can I ask you, please, to articulate what's the principle? We have to write an opinion. The
Because
same
that-
question I posed to your friend. We have to write this opinion. What is the principle that distinguishes acquitted from convicted conduct?
So acquitted conduct one thing that I think is supported by the commentary is that conduct that underlies an acquitted charge can be considered acquitted conduct. That's like the first step. The second step, of course, is whether that conduct can nevertheless be considered as relevant conduct. But that's that first step. What is acquitted conduct? What Judge Subramanian did is said acquitted conduct is conduct that underlies an acquitted count, right? And under that definition, in this case, there was a lot of overlapping conduct. And so he had to determine what
So how do we know whether there's overlapping conduct? Where do we look to determine that?
I think that's where the judge's discretion, the judge who's overseen the trial.
But this is, we're trying to find out what the purpose of the guideline is, to make sure that the jury's acquittal isn't negated. So we're trying to understand, this is difficult, right? We're trying to understand what the jury did. And we have a conviction and we have an acquittal, right? So we're trying to understand what the jury did.
So I think that the appropriate test here is the test that Judge Subramanian articulated, which is to assess whether the conduct can still be considered as relevant conduct for the purposes of the guidelines. He looked to whether that conduct tended to establish an element of the convicted count. And in this case, those two narrow instances.
Well, let me ask you that. Why does the coercion tend to prove, say, with the conflict? Why does the coercive nature or the coercion, strictly speaking, tend to establish the Mann Act, as opposed to, let's take coercion out of the equation, the fact, you can still look at the underlying raw facts, Mr. Combs coming back in the plane, sitting next to Ms. Ventura, showing the videos and all that, that evidence could still be considered, say, fairly to ascertain what Mr. Combs's intent would be for the events that would follow. And yet it could not, say, under the defense's view, be considered for purposes of establishing coercion, because coercion was an element of one of the acquitted offenses.
So I think to answer your first question, which is how does the travel in Cannes and the situation on the airplane, how does that establish the Mann Act? I think it's for the reasons that Judge, you articulated in your colloquy with my colleague.
And I'm saying, let's grant you that. Let's hypothesize that the events on the airplane are admissible and were properly considered by the judge to figure out, did Mr. Combs really intend what was all going to happen was going to happen? Let's just posit that. But isn't there a world in which the guidelines say, yeah, you know what, that's fine. Consider it for purposes of the Mann Act elements, but you can't draw the further conclusion that that was coercive in nature?
Well, the guidelines.
Because that's what the jury said did not happen, or did not find happened, and therefore it's acquitted conduct.
So I think because this acquitted conduct tends to prove an element of the Mann Act.
But how does the coercive nature of it, the inference that it was coercive, because I think that's really a distinct fact, right?
That inference is coercion is defined in the guideline. The fraud and coercion guideline, or excuse me, enhancement is set out in the guideline. And the definition under that, coercion under that enhancement.
Let's assume it is coercive conduct.
Sarah.
I think what Judge Nardini's asking, and I have the same question, is how does the fact of its coerciveness tend to establish some, in whole or in part, an element of the Mann Act offense?
I think it relates to the temporal proximity between the coercion, the threats, I'll call it, the threats, the transport, and the demand for a freak off.
So let's say the conversation instead was, instead of it being coercive on the plane, was when we get back, my plan is to fly some escorts in and you're going to have sex with them and I'm going to pay them for that.
Sure. I think that would establish the intent.
Exactly. So why is the additional aspect of that conversation, that encounter on the plane that's described, that the coercive aspect of that, why is that add anything to establish in whole or in part the Mann Act offense?
Because I think it's what he's asking for. It's the threats are not followed by a request to go to dinner. a request to, ask Cassie to do the dishes. Those threats are followed by a demand for a freak off. So the coercive nature of the threats are directly relevant to the intent to have the freak off, which then later happens.
Well, okay. Except you've agreed that it didn't need to be coercive in order to support that aspect, the
No,
intent
not
aspect of the
necessarily.
Mann
It
Act.
just so happened in these two specific instances, the threats did amount to coercion under the enhancement. And I think that was, I think Judge Subramanian.
Can I ask you a hypothetical? And I don't know, it doesn't map onto this case, but I'm trying to make sense of the acquitted conduct guideline. We have a defendant who's charged with murder. He points a gun at the victim's head. He pulls the trigger at point blank range, kills the victim. He's charged with first and second degree murder. The jury acquits of first degree, which would have required a finding of premeditation, but it convicts of second degree murder. Let's say it was, I don't know, some sort of heat of passion or something he just did on the moment. Comes to sentencing. Is the premeditation, which is purely mens rea,
Good question.
in your view, acquitted conduct or not?
Acquitted.
And if so, is the judge, in my hypothetical, allowed to make a finding of
No.
premeditation
No, he's not.
by a preponderance and sentence the defendant accordingly under the guidelines?
No, he's not. He's right.
So
Good question.
the premeditation, I think.
Because what I'm trying to do is draw a distinction between the actions, the physical actions. And I'm going to analogize that to Mr. Combs coming back in the plane, sitting next to Ms. Ventura, showing the video, saying the words he said. Those are sort of raw facts. Clearly, they underlie, in my hypothetical, clearly the underlying facts of the man reaching over with a gun, pulling the trigger, and killing a victim are raw facts. Clearly, in my hypothetical, they underlie
Good
the
question.
second-degree murder conviction.
Sure.
But the jury has acquitted on first-degree murder, meaning they have not found premeditation beyond a reasonable doubt. It seems to me that if we pursue the government's theory here, which is you can consider the facts surrounding the walking back in the plane, the showing the videos and all that, and then the judge can draw whatever inferences the judge thinks appropriate because the facts were properly before the jury on account of conviction, then the judge, in my hypothetical, would be able to find premeditation beyond by preponderance and sentence accordingly under the guidelines amendment. Is that your view?
I think that's right.
No.
I think that's right, Judge. Assuming I'm tracking your hypothetical.
And you don't think that that is
I
what
don't think so.
the commission was trying to avoid?
No, I think the commission understood that there's overlapping conduct, right? Especially in trials of this nature, where these different counts rely on the same factual instances to prove the different counts.
I guess just from a gut instinct, it seems like my hypothetical would be the prototypical example of what the guidelines as amended were trying to avoid. So it seems hard then, if that is the government's view of how it would map out in my murder hypothetical, it's hard to accept how plausible the government's reading of the guideline is more
Your Honor,
generally.
Great job, Judge.
Hypotheticals are, I find, very difficult in this context. The commission understood that these situations are incredibly fact intensive, and that's in large part because they only come up after a trial. And trials are all different, right? And evidence comes in different ways and weaves together differently. This is a very fact intensive inquiry. I think what Judge Subramanian did here is he looked at the entire record, all 8 weeks. And imagine that being like a pizza, right? He's thinking about the entire trial as a pizza, all the facts, all the evidence adduced during that 8 weeks. But in considering the guidelines, he's not considering that whole pizza pie. He's considering a slice. And what's in that slice It's what tends to prove the Mann Act. And that's why when he looks at the two specific incidents of coercion, those incidents are specifically tied to transportation. They're tied to the Mann Act.
And I guess that's where I'm suggesting that I don't know how to follow the pizza metaphor, so I won't try.
Yeah, the pizza.
That it's a little bit more analogous in my murder hypothetical, that the judge in my hypothetical can consider the physical actions of people, pointing the gun, shooting, the bullet hitting, the victim dying, but would not be able to consider the additional inference of premeditation. So you can still be considering the slice if the slice is considered the evidence that was put before the jury. But I'm suggesting, or I'm positing the possibility that the guideline might limit the inferences that can be drawn to the extent those inferences are part of acquitted conduct, and not also inferences that would themselves constitute an element of the offense.
I think that's right. Again, I find it very difficult to think about these hypotheticals in the abstract. But I think here that slice of conduct that the judge considered, those two very narrow instances of transportation, I think undoubtedly tend to prove the Mann Act and also meet the requirements of the enhancement under the guidelines.
Can I ask you, I don't know if I can change the subject a little bit. We talked about any number of issues today. Can I ask you specifically about the leadership enhancement? One of the very specific questions we were talking about with your colleague on the other side was whether, as the government submits, there are at an irreducible minimum 5 criminally responsible participants in the Mann Act. And the government, as I understood your brief, said, well, there's Mr. Combs, number 1. There are the 2 victims.
That's right. Cassie and Jane. Yes.
Cassie and Jane. So we're up to 3. And the government posited that the 2 escorts who were transported across state lines.
No, that's slightly inaccurate. Yeah, it's.
So why don't you clarify?
Of course, the 5 criminally liable participants, besides Mr. Combs, are, as you said, Jane and Cassie, the 2 victims, and then 2 of the owners of an escort service.
Oh, the owners of the escort service.
They weren't escorts themselves, but they were owners of the service.
I'm sorry.
Who facilitated the transport of escorts who worked for that service.
Oh, I see. And so your argument is that because they were involved in the transportation, and obviously, in your view, the evidence showed that this whole thing was clearly designed for prostitution.
That's right.
You're up to 5.
That's right.
If we were to agree with you on that point, does that make the whole question of acquitted conduct with respect to the leadership enhancement go away?
Yes, Your Honor. And I believe it could go away in another independent way, which is that the conduct was otherwise extensive. Which is another prong of the leadership enhancement. And I don't think that the defendant even challenges that in his reply. So the leadership enhancement is met in both of those ways. With respect to...
Were those, remind me, and I should know this, and I don't recall, did the government present arguments that the escorts and their employers were members of the alleged racketeering enterprise?
No, Your
or
Honor.
conspiracy?
The only individual that the government identified as a criminally responsible participant for the purposes of the leadership enhancement was Christina Coram, who was an employee of Mr. Combs and who was alleged...
My question was about in terms of when you argued the RICO conspiracy count to the jury. Did you argue that the escorts or their employers were members of the RICO conspiracy?
No.
So I take it your argument would be that to the extent the district judge could permissibly consider the escorts and their employers, there would have been no overlap at all with acquitted conduct.
Exactly.
That would be your argument.
Exactly, Your Honor.
And then can you remind us who the judge said, I know I have this here, who the judge said were participants?
who were criminally liable participants.
For the purposes of the increase, right?
Yes.
It's
James and Collins.
Ventura,
Ventura,
Doe,
Jane,
Coram.
Coram, who was the only employee.
And then
Okay.
James and Bridget Collins.
Bridget Kreshover Collins, yes.
Those are the two
Those are the
employers.
two
So if
escort
we knock
employers.
out, if we were to say to drop out quorum,
That's right. You still
hypothetically,
have
in
five
your view, you're still left
participants.
with 5.
That's right.
And that's, okay.
And that meets the enhancement. That's
And then
right.
he also said the services of numerous outsiders that were peculiar and necessary to defense,
That's right. And that is to
but
say.
some of whom he included as, among that number, his assistants.
That's right. But the assistants were not alleged to have been part of the racketeering enterprise. So that is, like I said, that's another way to support the application of the leadership enhancement in that case without even touching acquitted conduct or potential acquitted conduct. You know, with respect to the 3553A factors, you touched on this briefly with my colleague, but as Judge, you pointed out, the case law is binding that under the 3553A factors, sentencing courts can consider acquitted conduct. But I just point out that what the judge did here, what really drove his Section 3553A analysis, didn't rely on acquitted conduct. It didn't even rely on disputed issues to begin with. And let me just give you an example. In assessing the history and characteristics of the defendant, the court found that the defendant abused the power and control he had over the lives of women he professed to love dearly. He abused them physically, emotionally, and psychologically. That's not acquitted conduct. That was all admitted conduct. The defendant admitted from the outset of the trial that the defendant engaged in horrific domestic violence. And so all of that conduct was admitted. In assessing the seriousness of the offense, the court noted that the defendant plied Ms. Ventura and Jane with drugs. That was also admitted. The defendant admitted to personal use quantities of drugs that he shared with his girlfriends during freak-offs. That was admitted. In thinking about the seriousness of the offense, the court found that the conduct occurred for over a decade and with tremendous frequency over that time period. That has nothing to do with acquitted conduct.
On the drugs, let me just ask, if you had said he had drugs of his own and he shared them with Ms. Ventura and Ms. Doe, I understand your argument that's not acquitted conduct. You've just said he plied them with it, which sounds to me very much like coercion, which is what we've been talking about, may or may not be acquitted conduct.
The testimony was that the drugs were shared at these freak-offs and hotel nights with the girlfriends so that they could get through the freak-offs
Right,
and the
but the
hotel
word you
nights.
just used was plied, which to me is using the drugs to get their compliance and participation, which again goes back to coercion. But the fact there are at least facts that he shared drugs is the point. But did Judge Subramanian talk about plying?
Shared drug. Those were Judge Subramanian's
So
words.
that sounds like he's talking about coercion.
Well, I think the point of that is that he shared them, not just shared them with drugs, like shared them with girlfriends trying to be nice, but he shared them in the context of freak-offs and hotel nights so that those women could get through the hotel nights and freak-offs. They both
You're saying
testified.
there's sort of a level of misconduct that falls short of coercion? Is that what you're suggesting?
That's exactly right. That was admitted, and that those categories of misconduct involve physical abuse, which was fully admitted.
Did Judge Subramanian say anything to suggest that he was thinking about a category of misconduct short of coercion, or do we need to interpret those statements in light of what he had previously stated, which was that there was coercion, and that even if he could not consider the coercion under the guidelines, he would nevertheless do it under the 3553A factors. So why should we, in other words, why should we, considering he already said there was coercion, why would we not read those comments as his illustrations of the coercion rather than a suggestion on his part that they were misconduct that fell short of coercion?
I think you read the words of the conduct that he's describing, and what I've just read is admitted conduct. So call it coercion, call it physical abuse, it's admitted.
Well, but again, the words the judge uses are, you plied them to drugs, forcing Ms. Ventura into addiction. That may well be true, but our question is not whether that's supported by the facts. Our question is, doesn't that show the district court considering the conduct that is coercive? Because plying and forcing don't sound like something different than coercion.
I think that in this case, where the drug use and the drug sharing was admitted, I think that can't be acquitted conduct. I think that that's admitted conduct. And I think that the judge is free to consider it, and especially in the 3553A context, where there aren't restrictions on considering acquitted conduct under the binding precedent of this court. So I think that the judge was, I wouldn't necessarily agree that he's describing coercion. And I think even if he were, he would be free to rely on that in imposing the sentence under the 3553A factors.
At which point then we get into the constitutional question, if it is in fact acquitted conduct. That was not.
That's right.
Yeah.
That's right. What? We've been talking a lot about the guidelines and Judge Subramanian's application of the acquitted conduct guidelines. And the last thing that I would say on this is that even if Judge Subramanian made an error in his application and interpretation of the acquitted conduct guideline, which we don't think he did, but even if he did, that error would be harmless. And that is because he unequivocally and explicitly stated that he would impose the same sentence regardless of the acquitted conduct guideline. He reviewed voluminous sentencing submissions. He noted at the outset of the proceeding that there was a general lack of guidance with respect to this guideline. He considered the arguments of all the parties, and he provided detailed reasons for his application of the various enhancements.
Could you remind me, I think I asked this question to your colleague on the other side, just remind me. I recall that as he found individual sentencing guideline enhancements, he then would say, I impose this enhancement, even if the acquitted guideline conduct, even if the acquitted conduct guideline does not permit me to do so, I would impose the same sentence anyway. So he did this with respect to each of the three enhancements, right? Did he say something at the end that one could read as a wraparound? And even if I have erred with respect to all three enhancements, or did he only say that those three points?
So I think when you look carefully at the record, he noted that his sentence would be the same regardless of the acquitted conduct guideline with respect to the fraud and coercion enhancement,
right,
and with respect to the leadership enhancement. I don't think he made the same sentence, the same statement with respect to the victim grouping enhancement.
So let me ask you this. Wouldn't there be an argument on the other side that even if we were to take at face value the district judge's statement that he would have imposed the same sentence, even if any one given guidelines enhancement was erroneous, if we were to conclude that two or more were erroneous, then we don't know what the sentencing judge's intentions would be, and we would normally send it back. Is that, would you agree or disagree with that statement?
I think I disagree, assuming I'm tracking this correctly. And I would point to the Jass and Dara cases from this circuit, where both courts were interpreting a new guideline enhancement. And like in the case here, where Judge Subramanian was interpreting the new acquitted conduct guideline. And in those cases, the courts noted that this was a new guideline, there was some ambiguity, and that even if they got that guideline wrong, which the court ultimately decided they did, they would impose the same sentence regardless. And that's exactly the situation that we have here. With respect to the acquitted conduct guideline, which is the guideline that could affect the fraud and coercion enhancement and the leadership enhancement, Judge Subramanian specifically said that it doesn't matter if the acquitted conduct guideline applies here or not, I would impose the same sentence. He did not say that with respect to the victim grouping enhancement, which has nothing to do with the acquitted conduct guideline. And I think that's a good example of why Judge Subramanian's statements that he would impose the same sentence regardless are not just simple incantations of magic words to evade appellate review. He specifically noted the ambiguity of this particular guideline that would affect those enhancements, and therefore any potential error, which of course we would submit there is none, any potential error would be harmless here.
Can I ask you this question? Would his 50-month sentence be substantively unreasonable in the absence of the district court's factual findings as to violence and coercion?
Just as an initial matter, the substantive unreasonable argument, I think, was waived. That was not raised by defense until the reply brief.
That's, again, a matter of nomenclature. They make a pretty good argument in their opening brief that then substance is that the sentence was substantively unreasonable. But so I understand your point about waiver, but continue.
So the
Well, we know two judges are on their side.
So
defense side.
in determining whether a sentence was substantively
Aper
unreasonable,
and Sarah.
this court has to review in light of the 3553A factors. And as I mentioned, the 3553A factors were very thoughtfully considered by the district judge.
I realize that, but if we took off the table the violence and coercion, would this pass muster as, would this be a substantively reasonable sentence?
Your Honor, I don't think you have to, because under the 3553A factors, all acquitted conduct can be considered.
Right.
But even if you did,
I realize that, but let's assuming for the purposes of my hypothetical, assuming that we take off the table the violence and the coercion, right? Would this sentence be substantively unreasonable?
Yes.
Your Honor, the
50 months for the man.
with the caveat that I strongly disagree that we need to take anything off the
Fully
table
noted.
for
Preserved for the record.
3553A. A sentence is only substantively unreasonable if it is manifestly unjust or shocks the conscience. And we see that sort of dynamic in some of the other cases. I'm thinking of the Jones case in which Justice
Yeah, they're gonna lower his
Scalia,
sentencing.
dissented. I can't remember the difference between the
That
guidelines
question
without
gets not
consideration
right,
of acquitted conduct, but it was something astronomically high. And here, the 50-month sentence was below guidelines and reflected the fact that the judge really did consider the fact of the acquittals. If the judge had just ignored the acquittals and sentenced on the trafficking or the racketeering, the sentence would have been at least 15 years. There's a 15-year mandatory minimum term with a trafficking charge. This 50-month sentence was well below and well in line with other cases in this district. Judge Subramanian was very focused on other Mann Act sentences and asked the parties to provide a list of Mann Act cases and the sentences. And so he was fully aware of the different ranges of sentences that Mann Act defendants get. And that was a consideration, of course, under the 3553A factors, but it was appropriately weighed against other 3553A factors.
That was a no? I just want to be clear. Is that a no? It would not be
I don't
substantively
remember the
unreasonable?
original question, but I think that's a no. Your Honor.
Let me rephrase my original question. So I was you're very good at evading my question. So it's very good, actually. If I was a district judge, I would say the witness will be responsive to the question. Would his 50-month sentence be substantively unreasonable in the absence of the factual findings of violence and coercion?
And the answer is no. Thank you, Judge Nardini.
That's
The
what
only
I
thing-
thought you were going, but I wanted to make sure that we had an answer to the question. And let me just ask you on the substantive reasonableness point. I think what I think I heard you said is that it wasn't raised in the blue brief, right?
That's right.
So, and this is a procedural unreasonableness claim that the guidelines weren't followed and there's violation of the Sixth Amendment. That's what your response is?
Sorry, say that again?
And that it's a procedural reasonableness challenge that goes to the guidelines and then to the Sixth Amendment
That's right,
issue
Your Honor.
about fact finding. That's what I understood your response to be.
That's
Okay,
right.
just
Your
wanted to
Honor.
make sure I-
Much more succinct than.
Yeah,
than
and I got
put
the
that.
response that I understood what your view of the framework is. Thank
Yes,
you.
that's right. The only thing that I want to add relates back to the Mann Act, and I just would correct the record that in closing, in the government's closing argument, the summary chart that the government pointed to did include the incident related to Jane that took place in, I think it was October of 2023, where the defendant made threats to Jane's friend. And then
Do you have a page number in the appendix just so we have it handy? If you don't,
I
that's
have
fine.
the government exhibit, which is
Yeah.
1406.
1406?
Yes.
Yeah, we'll find it.
All right, thank
Okay,
you.
I think we have exhausted our
Sorry,
supply
let me
of
just,
questions.
Counsel,
No?
you're saying that
We
that
did not.
argument was raised in your closing about Jane,
Yes, it was in the summary chart that the government relied on. It's lines.
and that's sufficient to say that you were arguing that Jane was transported as a premise for the Mann Act conviction in count 5.
That's right. And that's at line 38 on government exhibit 1406.
Yeah. Again, even though the actual verbal summation says, for the defendant's hotel nights with Jane, there are also many examples of the defendant transporting escorts. And that's the discussion you have verbally. And you do say in passing here, by the way, check out 1406. You should refer to that chart. It has a lot of information in it.
That's right, Your Honor.
Okay, thank you.
Okay.
I'm sorry. Just to clarify, the escort traveled for that particular hotel night. It was not Jane who traveled, just to clarify.
So that exhibit 1406 is going to show us, in your view, that the escort traveled for that episode with Jane.
That's right.
That Judge Subramanian talked about at sentencing.
That's right, Your Honor.
Got it. Anything further? No? Okay, thank you very much to the government. Believe it or not, you have
a
You have
few
reserved
points.
2 minutes, but we're going to give you a little bit longer because this has been extensive, but we're not going to go crazy because we have kept you up considerably past your initial time. Why don't we try to keep it to 5 though? So
Thank you,
just your
Honor.
highlights.
I'll go as quickly as I can.
Because your briefs, I will say this on both sides, briefs are excellent, really do a great job laying out the issues. This has been very helpful, but why don't we give 5 minutes of rebuttal? So I'll just ask the courtroom. There we go. We've
Just real
dialed up
quickly
the
on,
clock.
on the point about Jane, and I don't want to dwell on that. Our argument about Jane, which is set forth in the reply brief, is not that that hotel night didn't occur. It's that wasn't connected to any threat, and there's no evidence of any threat. With respect to the harmless error issue, I want to highlight a couple of points. First of all, under all the case law, Gall, Rita, and their progeny, substantive unreasonableness is determined based on the guidelines as a starting point, just as the guidelines are a starting point.
Yeah, but you didn't raise substantive unreasonableness.
what
You have
we
a brief
raised-
full of procedural unreasonableness.
What we've argued is that if we're right about one of the reasons we're right, that a remand is required is that if we're right about the guidelines, the sentence would be.
Sure, that I
substantively-
get the anchoring
That's the point
function.
there, and we rely on the Jones
Hey,
case
don't play with her.
also for the point that acquitted conduct, using acquitted conduct would make the sentence unreasonable. With respect to, I do want to be clear on the 3553. My friend on the other side kept saying that we admitted that our client plied Cassie with drugs and so on. None of that was admitted. That's not what was admitted. What was admitted was the unfortunate domestic violence only with respect to Cassie.
But you don't dispute the district court's factual findings here. The district court made factual findings that he plied them with drugs.
Well, we
I mean,
we did dispute that below, but
but
more
here you're
to the
not.
point.
I mean, that's a fact we take as a given because that
Well,
factual.
the evidence was quite mixed, and there was a lot of debate about this in the trial. And I think one of your honors in their questions got at the fact that the government's arguments about the drugs were part of their arguments about coercion, the way in which the drugs were used, and so forth. But I don't want to dwell on that. I just want to be clear that that was heavily debated at trial, and that was part of what he was acquitted of when he was acquitted of sex trafficking. With respect to the leadership, just real quick, we do contest the otherwise extensive as well. This court's case law actually highlights that with respect to otherwise extensive, it is kind of a head counting exercise anyway. And the owners of those escort services were not criminally responsible. There wasn't evidence of that. Those were legitimate businesses, and there's actually text messages where one of the people is telling Mr. Combs that you're just paying for their time. But most importantly, I want to turn to the acquitted conduct guideline. Under the government's view, the guideline would be totally pointless. McClinton itself, which is probably the proximate cause of the commission sitting down to write the guideline, illustrates the point. In McClinton, the defendant was acquitted of a murder charge and convicted of a charge that involved an armed robbery. And so clearly using the gun was underlied the robbery conviction, yet the defendant was acquitted of murder. And so
I was telling myself I wasn't going to ask you any questions in rebuttal, but I am. Could you respond to the hypothetical I gave to the government about the first and second degree murder case where the defendant is acquitted of first degree premeditated murder, convicted of second degree murder? What, in your view, assuming the only difference in the elements is premeditation or not, just posit that, what is the acquitted conduct in that case?
I assume that the government would have had to put in some kind of evidence that.
Oh, I'm sorry. I'll remind you. My hypothetical is, let's say this is the only evidence in the case. The defendant reaches over with his loaded gun, puts it at the temple of the victim, pulls the trigger, and the person dies. That is the sum total of the evidence. And the jury acquits of premeditation, but convicts of second degree. In my hyper simplified hypothetical, what is the acquitted conduct?
I mean, I guess I feel like I would have to know more facts, but obviously the
Nope, that's
defendant
it.
was
That's
acquitted
it.
of having decided to shoot the person with
She didn't get it. Yeah, you had
premeditation.
time.
Maybe it was in the heat of a fight or something like that. So that they were acquitted of the premeditation, but convicted of killing the other person intentionally, nonetheless.
She messed up, y'all.
I-
Messed up. She messed up.
I guess my where I was thinking is that all of my evidence is acquitted conduct. The pointing,
Yeah.
the pulling the trigger, and the killing, and the premeditation is all acquitted conduct.
And the
But under the
convicted conduct is
guidelines,
just
you
the
can
death.
look at all of the conduct, the pointing the gun, the pulling the trigger, the shooting, because that constitutes an element of the second degree murder. But you can't look at the premeditation because it's an element of
I
the
think
first
that's-
count, but it's not an element of the second count.
I think that's.
But I don't know if
correct.
that's right.
I think that is correct. It's similar to another. My time is running out, but there's a hypothetical that's discussed in the hearings that led to the guideline in which someone poses that there's an arson and there's a charge that the arson was racially motivated, and the defendant is convicted of an arson charge but acquitted of the charge that involves the racial motivation element, which is similar to that hypothetical. And I think the answer is the defendant is guilty of arson, but you can't enhance the sentence based on a racial motivation. And I think that's just like this case where, the Mann Act doesn't require proof of the coercion.
I stole a couple of your minutes, so we'll give you 2 more minutes.
I just
Give
in
her more
closing,
minutes.
12 New Yorkers took
favoring
2
her,
months out
y'all.
of their lives to serve on this jury. They listened to 34 witnesses, reviewed thousands of text messages, videos, and other evidence, and deliberated for 2.5 days. Their unanimous verdict was not guilty on the most serious charges, and The jury did not authorize punishment for sex trafficking or conspiracy, but that's what drove the sentence. Here, we submitted the evidence that my friend on the other side describes, which I would urge your honors to look at, which is at docket 510-4 of the district court, shows that this was the highest sentence ever for this type of charge with this type of criminal history. And in closing, this appeal has been expedited, and actually, I forgot to say, we'll rest on our briefs. We have also argued the convictions should be reversed, but if the court doesn't do that, the appeal has been expedited, and we would, understanding the complexity of the issue and the importance of the decision, respectfully request that the court, regardless of the outcome, endeavor to decide the case as quickly as possible.
Quickly as possible.
Okay, thank you very much. We will reserve decision, as we do in all cases. Let me just close by thanking counsel on both sides. This is an exceptionally difficult case. This is a question of first impression, not only for this court, but apparently for any federal court of appeals in the country. And we appreciate the quality of the briefing and argument on both sides today. So thank you very much. And with that, we have completed the business for which this court has been convened today, and I would ask that court be adjourned.
Boom! Court has been adjourned, y'all. Listen, we will be talking to Sean G in a few when he gets out, with the other people when they get out. So I'm going to get some text messages. I'm going to shout out to the folks that are in here. I know y'all in here. So shout out to the people that are in here because they just let me know they were in here. Some special guests. I can't tell y'all who they are, but know they're in here. Thank you for the text letting me know that you guys was in here. But before I got some folks that are in New York who went up there, a couple of the news people, and they've been like texting me, telling me some stuff is going on. But to the Diddy people, thank you for being here. I appreciate y'all. I'm waiting for Sean G to come on out. Please, the man did his time. You know, they're gonna do this one pretty quickly because Shapiro just asked for them to because it was expedited. So they probably asking them to do it within a couple of weeks or something like that. You know what? Sean said, tomorrow's headline, Christy Slavic to be featured on Food Network Chopped air next week, Monday at 8 a.m. Oh my God. Please don't forget to hit the like button, y'all. Thank you for all the people who subscribe to the channel while watching this. I appreciate it. I saw the numbers going up. I appreciate you guys. Thank you. I try to get you guys the information. I knew it was going to be on there. You said, go Diddy. Hey, Anthony. Hey, Queen. Hey, Diddy. Hey. Rara, you out there? Rara, you going to be outside? Oh, shout out to the special guest. Yeah, I can't tell y'all who the special guest is, but y'all can almost guess who the special guest is, all right? Y'all can guess, right? I could tell you they connected to Diddy. I could tell you that. Okay. How about that? I could tell you they connected. I can't tell you who they are, but I could tell you they connected. Argument makes government follow the law. They should win. You know what? Both of us get on my nerve because I said to him it's only going to be 10 minutes. He's like, sometime it go up to 45 minutes. I said, I've never seen it go to 45 minutes. The most I've ever seen it go is 30 minutes. And now he has proven me wrong. It went beyond the 45 minutes, he said. It went beyond the 45 minutes, he said. Y'all sitting there guessing too. I was just joking about you guys guessing. What are y'all doing? What's wrong with y'all? I was joking. I was joking about you guys guessing. They sitting here guessing, y'all. They're guessing who's in the chat. You said 6 to 3 months? 6 to 3 months for what? You said Diddy's going live. You so silly. Oh my God. Y'all just be making up stuff. What do you think? Corey, what do I think? I think it was rough for Shapiro in the beginning because that judge was just boom, 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 boom. But I tell you, two of the judges were more leaning towards the defense. That one judge was the government, but then I started hearing him. He started moving towards defense, so it's kind of like close, very close, close, close. Well, we'll find out who was in court. Sean G is gonna tell us who was in court. Shout out, we had over 700 people in the chat. Shout out to the folks that came in. I have gained like 30 new subscribers. Thank you guys. I appreciate you. I wish Mr. Steele was doing the all close but oh well. Greg said, it's just my opinion. They're going to drop some of them enhancement. Definitely. He's gonna get time served. Alicia, I agree with you. Overcharge. They kept talking about that. Yes. Overcharge, over sentence. Yes. And remember, he's been doing some classes and stuff like that. So his time has been like inching up anyway. So I am thinking that he is going to be out real soon. It's just it takes a matter of how long they're going to take to make the decision. And usually right after they make that decision, they'll be out or whatever. Because remember, he only has to do 85%, right? And if they cut down the time, some of those enhancement, they cut it down, he'll have time served and he'll be home. I don't think they're going to overturn the whole case. I think they're just going to do the adjustment of time. I think you're just going to do adjustment of time. Is Sidebar on yet? Is he coming on yet? Is he coming on yet? Because I know they have to come out the building. Once he gets on, I'm going to get off. And then later on, him and I are going to come together. Because, that's my bro. Let's see. Hold on a second. Sidebar, is he coming out yet? Let's see. Let's see if Sean G is coming out yet. Let's see. Let's see if Sean G comes out yet, y'all. Let's see if Sean G comes out. Nope, he's still up there. He didn't come out yet. As soon as he comes out, we'll get on. We'll start talking. We'll get off. But as soon as Sean G come out, I'm waiting for some of them to come out. I would love to know what Tisa Tells said about this. Well, she didn't go on live. She didn't go on live yet. We'll see what she says. I mean, now she can't tell a fib because you guys heard it for yourself. So if anything doesn't match what you heard for yourself, then you need to go, talk to her about it. Because his $200 online was worth it today, LOL. Yeah, it was worth it, yeah, because it would have been only 10. Yeah, his 200 was worth it because he had 2 hours. It was worth it. It was worth it. He had 2 hours. I want to know who was there. He's going to tell us all of that, right? We're waiting. We are waiting for Sean G to come on out. Let me see what my other people in the courtroom says. Hold on a second, because I got so many folks that's in the courtroom. Hold on, y'all. Hold on. Let's see what they're saying. See who got their phone out first. who went downstairs and got their phone out. Hold on. I got a lot of the news people that's in there. Let's see if there are any of them. Okay, I just text them. You know what? You guys are. See, I'm talking to the folks. Let's see what they say. They still trying to get their stuff. They're not out yet. There's only 2 people online. Me and somebody else. There's quite a few people that probation is better get. Yeah, definitely probation. They're probably gonna ask for it. Country Boy Fitness. Hey. Hey, Country Boy Fitness. You need to be in the hallway? Oh, I need to be in the hallway. I need to, you guys. You need to be in the hallway, right? I'm shocked how much people overlook his bad behavior. Wow, I'm shocked. Keep him locked up. Jarrell Morris says that. Sean G knows everything what's going on. Yeah, he should be coming out in a minute. What time Puff goes home? Free him. It's time. Sorry, it's time. You said. If he gets a sentence reduction, how does that affect strict probation that was imposed on him? I don't know. Tracy. They probably go back and relook at that one. I don't know. I really don't know. Yeah, Sean G is there. Yeah, Sean G. I'm waiting for him to come out. As soon as he come out, I'm gonna get off my live. As soon as Sean G comes out, I'll go on my live. He is the only one there, and I got some other people that's there too. Yeah. Just waiting. Hold on a second. Let me tell y'all what they saying. Hold on. Let me tell you what they just said. What? This guy just said Diddy could be free today? Huh? All right, let me let y'all hear what TMZ said. Okay, I'm gonna just play it for y'all because I'm not gonna play that thing because I don't want them to strike my channel thing. Let me just play it for y'all. Because these people will be funny and start doing strikes and stuff like that on your channel. Hold on.
For Sean Diddy Combs will be in federal court today.
They're coming as they appeal the disgraced hip-hop mogul's conviction and prison sentence. Briella Thomasetti, what's going on with this?
Rosanna and Dan, good morning. So Sean Diddy Combs' lawyers will try to persuade a panel of 3 federal appeals court judges that he was treated unfairly at the trial that sent him to prison on prostitution-related charges. And they say he should immediately be released or freed and resentenced to less time. Diddy is not, by the way, scheduled to appear at today's court hearing, which is slated to begin at 10 o'clock. In written arguments, Diddy's lawyers claimed that the recordings of sexual encounters between his girlfriends and male sex workers amounted to amateur pornography that were protected by the First Amendment. They also say the judge in the case unjustly let evidence surrounding the acquitted charges influence his punishment. Federal prosecutors opposed those claims, writing in court papers that Diddy's recordings don't make his case a free speech issue. They said if his creative, elaborate, and highly staged sex acts meant that they were protected by the First Amendment, then, quote, brothels offering elaborate and staged scenes for individuals to have sex with women for payment should claim the same protection. Last year, a jury found Diddy guilty of 2 charges of transportation to engage in prostitution.
All right, so that's what they said earlier. So I want to hear what they say now. I want to hear their thoughts now, because I see nobody's rushing to get on the on their live to coverage. I don't see nobody going in to so quickly go live. Y'all notice that? Y'all notice that? If you ever notice when things are really, really, really bad for a defendant, that people rush to talk about it, right? When a thing is like in the favor of a defendant, they team seems to be very slow to come about and talking about it. That tells you a lot. Yeah, you see that, big boy? You see how are they saying that he needs to get out? Listen, let's play his. Okay, hold on. This is what they say.
There is a good chance that Diddy could be eating dinner at his home tonight, a free man. And that's because an appeals court is now hearing the review of the trial.
First of all, he will not be out to eat dinner tonight, because they never do that argument that quick. They never come out with their opinion that quick. So that's a fallacy. That's a clickbait comment, okay? That never happens, okay? Now, a week, yes. But the same night, nah.
Which Diddy was convicted of violating the Mann Act. And his defense lawyers are making 2 arguments that could sway these judges and make them overturn the conviction. Let me explain both. So the first is that the defense says that the violation of the Mann Act is to prohibit the transportation of prostitutes across state lines, and it's typically for commercial purposes. That's where they've used it before. In this case, the defense is saying this is nothing more than kinky porn, and kinky porn is protected by the First Amendment. Now, that may sound crazy, but I'm going to read you something from their brief. Listen to this. They say, freak-offs and hotel nights were highly choreographed sexual performances involving the use of costumes, role play, and staged lighting, which were filmed so Combs and his girlfriends could watch this amateur pornography later. Pornography production and viewing of this sort is protected by the First Amendment and thus cannot constitutionally be prosecuted. So what they're saying is, look, if you want to use the Mann Act to prosecute people who are moving prostitutes across state lines,
you hear that, right?
Transactions, which again is what it's usually used for, that's one thing. But here, there's no commercial purpose. Diddy lost money. He ended up paying the prostitutes. The films were never distributed to anybody. The defense is saying it was for his pleasure and the pleasure of people who may have been participating. So they're saying, look, this is like any porn. It could be OnlyFans. It could be anything like that.
OnlyFans?
And all of that is constitutionally protected and shouldn't be prosecuted. So that's one argument. And I got to say, it is an interesting argument. The prosecutors are saying it's meritless, but I wouldn't be so quick to judge it that way. So we don't know what the prosecution is going to say beyond that in court. But these judges, as I'm recording right now, the judges are hearing these arguments. The second thing they're arguing is that the sentence was totally out of whack, that Diddy got 50 months for violating the Mann Act. And typically for Mann Act prosecutions, the average is around 15 months. And what the defense is saying is that the trial judge in this case considered all sorts of evidence that he shouldn't have, that the judge, even though Diddy was acquitted of racketeering and sex trafficking, and there was a lot of evidence presented about coercion and force, and the Cassie video was introduced into evidence. The defense is saying none of that should be considered because the Mann Act has nothing to do with that. But they're saying the judge's sentence was colored by all of those things, and the judge threw the book at Diddy when the judge should have just looked at the Mann Act violation and then sentenced appropriately. They're saying the appropriate sentence should have been around 15 months. Well, guess what? Diddy has already served 19 months. So if either of those arguments fly, if the appellate court believes that this is constitutionally protected porn, or if the appellate court believes that the sentence was out of whack, 15 months is more appropriate, either one of those, Diddy is a free man. So the oral argument, as I said, is going on right now. Typically, and I'm sure it's going to happen in this case, the judges are not going to rule from the bench. That just never happens. So they will meet and confer, as they say, and write an opinion. But sooner rather than later, if the appellate court buys what Diddy is trying to sell, he could be a free man relatively soon.
Y'all said tonight, y'all. Y'all wrong. I told you it's not tonight. Somebody said people advocating for this guy, Jesus gotta go. Stephanie said bye. Stephanie funny. Free Puff. Harvey needs to go back to Guthrie's case, say bye. Free Puffy Daddy. See ya, Swiper. It's not a porn business when you created a trial of victims. So why y'all lie and say today, LOL? Okay. All right, yeah. I think folks are getting really, really upset here. I'm just waiting for what's the name to come on out, because you guys are folks getting a little bit irate around here. I was waiting for the folks to come on out. They should be coming out now. I'm waiting for trying to get messages from folks that are at the courtroom, in the courtroom. This is a very difficult case. Okay, this is a very difficult case. There are major legal issues that to be decided, so there's going to be considerable time before a decision comes down. I agree with you, James. I agree with you. Tracy said, thank you so much, Sylvia. You are so informative. I tried to be. Sean G, where are you at? Yeah, where's Sean G at? There were no victims, just Free Puff. Queen, there are people saying they beg to differ from what you're saying. Okay, I'm waiting for somebody to come out and say something, y'all. They're not even saying nothing. They're just mute. They're quiet. They are very quiet, y'all. Why are they so quiet? Nobody's saying anything. What's up with that? When you want them to say something, they don't say anything. They're not saying anything.
Certainly raised concern. Many will be made.
Oh, they're talking about. Oh, okay. There's nobody talking about it, y'all. Queen, I agree. What did Queen say? Let's go. They sure didn't have this energy. They sure didn't. No. Thank you, big boy. Why? You know what? Let me just let me woosah for a minute. Let me woosah. Thank you, big boy. Thank you for that statement. Hey, stranger. How are you? Let's see. I agree with Queen. Say if it ain't stick that and become. He still ain't even go to trial. He's still considered incompetent to go to trial. What about that? How about that, y'all? Still incompetent for him to go to trial. Mm-hmm. I'm going to leave that comment right up there for a minute. I'm going to let you guys marinate on that comment. Glad to finally see some Black people with sense. Let him or not or happen to both was unjustified. If it don't fit, must acquit. Okay, it was so many people who had their mouths on him during trial. Now it's cricket. It is crickets. I just want to leave that comment right here. You see the name here? Abercrombie and Finch. I need that comment to stay right here. Because you know what, guys? This dude still has not gone to trial. Diddy has had his trial in the jail and all that kind of stuff. And this dude still has not been to trial. What does that say about this society, the justice system? This dude has not been to trial. What does that mean? Nebby Debbie, you said, what does that mean? What does what mean? What do you mean? What does that mean? Do you know anything about this case here? The case I still have? He definitely is. He's home watching TV. He has never been tried. Never been tried. Never had to see a jury. He's still home. Still home. Nobody ever brought any charges against Hugh Hefner. What about Tyler from that group? Steven Tyler is his name? Steven Tyler? Where he put the little girl up in the house, set the house on fire. Oh, Sean G is on? Okay, thank you. Sean G is on, y'all. I'm about to get off. Bye, y'all. See y'all later. Let's go watch Sean G together. All right, see y'all later.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night.